stating that the agency had not provided any of the internal communications or memoranda in response to the October 17th letter. It was not until March 21, 2013, over 5 months after the original request, and after being threatened with the possibility of a subpoena, that FDA fully complied with the committee's document request. It should be noted that the Massachusetts Department of Public Health had fully complied with the committee's document request, turning over thousands of pages of documents related to its interactions with NECC before the November hearing took place. On April 16, 2013, the O&I subcommittee held another hearing entitled "A Continuing Investigation into the Fungal Meningitis Outbreak, Could It Have Been Prevented?" and released a 43-page report on its investigation into the NECC tragedy. The report stated that FDA had been aware of potential problems at NECC since 2002. During her testimony at the November hearing, Dr. Hamburg repeatedly expressed uncertainty about FDA's authority over compounding pharmacies, partially due to conflicting opinions on the matter issued by two different circuit courts of appeals in 2009. This uncertainty, however, has not stopped FDA from engaging in multiple enforcement activities against compounding pharmacies engaged in practices similar to those of NECC's since the outbreak took place. This year alone, FDA has announced recalls from compounding pharmacies in Augusta, Georgia, and Lake Mary, Florida, and St. Petersburg, Florida. In addition, the FDA in October of 2012 was prepared to issue new guidance related to compounding enforcement under its authority under Section 503. Since the outbreak, however, the FDA has called for new authority that creates a new category of compounding manufacturers. From what I understand, there are concerns that creating this new category could undermine drug safety by lowering standards and also weaken intellectual property protection. I would like to thank Dr. Woodcock for appearing before us today to explain her understanding of FDA's authority over compounding pharmacies and what actions the agency is taking to ensure that future outbreaks can be prevented. And I would also like to thank all of our other witnesses for sharing their expertise on compounding and its importance to patients. Thank you, and I'll yield the balance of my time to Congressman Barton.
Thank you, Mr. Chairman. I'm glad to be here today. We're glad to have Dr. Woodcock. She's a longtime witness before the committee, and we have great respect for her. We look forward to hearing what you have to say. I think it's pretty obvious to neutral observers that the facts do indicate that the FDA had authority that it refused or chose not to use in the situation that we're investigating. I'm sure Dr. Woodcock will elaborate on that and may have a counterpoint of view. Mr. Chairman, on the second panel, I have a good friend and former constituent, Mr. Joe Harmison, who's in the audience. He's the past president of the Texas Pharmacy Association, the past president of the National Community Pharmacies Association. He's that rare breed. He still owns and operates his own pharmacy. The only thing I can find negative about him is that he graduated from the University of Oklahoma School of Pharmacy back in 1970. Other than that, he's a great guy and a good friend, and I'm sure he will be very helpful in his testimony on the second panel. I might also take personal privilege just to say that Mr. Shimkus, to my right, threw out a runner at third base today in our inter-squad game as we get ready to battle the Democrats who've beat us the last 4 years in the congressional baseball game. So Shimkus is getting in game form. With that, I yield back.
Chair, thanks, gentlemen. I recognize the ranking member of the subcommittee, Mr. Plone, 5 minutes for an opening statement.
Thank you, Chairman Pitts. I'm pleased that the Health Subcommittee is finally having a hearing to examine drug compounding, but unfortunately we're months behind. While we're having our first hearing today to gather information on this topic, our colleagues in the Senate have already worked together to produce and mark up bipartisan legislation in the Health Committee. And so I think this delay is regrettable here. Access to compounding drugs is crucial for patients who have unique medical needs. We know that the New England Compounding Center that distributed the contaminated compounded product last year, resulting in the meningitis outbreak that claimed over 50 lives and infected over 700 patients, was clearly a bad actor. However, NECC will not be the last bad actor. Similar tragedies will undoubtedly occur again unless we address the significant gaps that exist in the current regulation and oversight system of compounded products. If patients are to have confidence in the safety and quality of these drugs, we must ensure that compounders meet safety and quality standards. While traditional compounders who mix medications to fill a prescription for a specific person are regulated at the state level, and drug manufacturers are regulated by the federal government, there are a growing number of companies that do not fall into either of these categories. Many companies are compounding drugs without prescriptions and shipping large quantities of the products across state lines, in essence acting more like manufacturers than the traditional compounders. In the absence of clear lines of authority, these companies experience very little state or federal oversight. So as we begin to examine drug compounding, I urge my colleagues to use this as an opportunity to move forward to determine what changes are needed rather than looking back and casting blame. We must stop questioning whether the FDA needs new authority. In fact, the past few months of examination by our Oversight Committee and the Senate Help Committee, it's become abundantly clear that conflicting court opinions and ambiguous language in the law show that the FDA does not have adequate authority to oversee compounders. And that's why I support efforts to help identify a new category of companies to be subject to federal regulation and oversight and provide FDA the tools and resources it needs to properly regulate them. So, Mr. Chairman, I hope today can be the start to this committee coming together in a bipartisan manner to address this issue and create greater clarity in the law so that tragedies like the one involving NECC do not happen again. The American people certainly deserve that the drugs, or should know that the drugs that they receive are safe and effective. So I thank all our witnesses. I know we have a second panel. I look forward to hearing about how Congress can best address the gaps in regulation and oversight that were unfortunately highlighted by the NCC meningitis outbreak, and how all stakeholders can work together to protect the public health. I don't know if anybody wants any of my 2 minutes on my side. You would, Mr. Dingell? I yield to Mr. Dingell.
I thank the gentleman for yielding. I thank you for having this hearing. I welcome our first panel member today. It's good to see her back before the committee. This committee has a great opportunity. We can quibble all we want about whether we have the authority and whether it's needed or not. Simple fact of the matter is people are dying, people are being made sick. And many people in this compounding industry, if that's what you want to say, have been studying ways to get around food and drug regulation and to continue, for all intents and purposes, becoming manufacturers. The question is, do we want to persist on that while we engage in a monstrous quibble, or do we want to get down and cut the corners that come from courts and judges trying to resolve a question that's probably well beyond their competency? Having said these things, I would urge us to move forward on legislation, effective legislation. This committee has a remarkable history in this Congress, which is noteworthy for having done very little, to have in fact moved forward with a number of important pieces of legislation in a bipartisan fashion. I see no reason why we should not continue that kind of effort with all the blessings to the public that obtains. So I would urge us to move forward. Let's put these rascals in the compounding industry into a place where they have law to obey, where everybody understands what it is, and where we can make our people safe. My state of Michigan suffered huge losses to people in sickness and death, stemming from wrongdoers who were deliberately skating around the law. And unsafe pharmaceuticals well beyond the reach of Food and Drug were in fact poisoning and killing our people. This is a wonderful opportunity. I commend you for making it possible. I look forward to working with you. I commend my colleague, Mr. Pallone, for his wise counsel and leadership. And I look forward to working on this matter in an effective way where we do go forward together to solve a major problem for our people. Thank you.
Chair, thanks, gentlemen. Now recognize the Vice Chairman of the subcommittee, Dr. Burgess, 5 minutes for an opening statement.
Thank the Chairman for the recognition, and I do support the efforts to examine the role that traditional compounding pharmacists play in the healthcare system. I know the value that they provide, having used them in my practice for a number of years. But we're also going to hear this morning how this incident necessitates broad new authorities. Recently, the Food and Drug Administration has inspected over 50 compounding facilities. You have to ask yourself, by what authority did these 50 inspections occur? If the FDA has the authority today, they had it 6 months ago. Fact is, one of the following statements must be true. The agency is acting without authority and risking litigation, or they have the authority and have always had the authority and have simply failed to use it. Documents obtained by the Oversight and Investigation Subcommittee are deeply troubling and I believe show FDA negligence. New England Compounding Center was making upwards of 30,000 vials of product without prescriptions, and yet the Food and Drug Administration questioned whether they had authority under the Food, Drug, and Cosmetic Act over manufacturing. The Food and Drug Administration was aware that this compounding facility was making poor products for years. They never followed up on warning letters. Frustrated FDA staff could not even warn the state of Massachusetts. Whistleblowers, doctors providing dozens of adverse event reports, and law firms dealing substandard conditions came forward, and the FDA did nothing. They didn't even pick up the phone. This is an example of circling the wagons after the crisis, and this member is having none of it. The bureaucracy held up the guidance for years. Testimony is provided through our Oversight and Investigation Subcommittee. The testimony that has been provided to both the Oversight and Investigation Subcommittee and this subcommittee today has been carefully crafted to avoid asking who failed America and who allowed NECC to introduce contaminated product into the supply line. I cannot in good conscience entertain discussion of legislation when not one person has been fired, reprimanded, or held culpable at the Food and Drug Administration. In fact, legislating transfers the blood of those dead and harmed from the agency responsible to us, the subcommittee, and to Congress. Massachusetts fired people because they should have known, and yet the Food and Drug Administration, who did know, now wants new authority. To what end is new authority going to provide protection to the public if the Food and Drug Administration, by its own admission and track record, refuses to pick up and use the tools they had at their disposal? The Food and Drug Administration refused to go after those operating so far outside the bounds of legality and traditional compounding. Why in the world would we trust them to regulate a legitimate compounder? Until the agency admits where it failed the American public, I, for one, am not going to be a party to letting them get away with this dereliction of responsibility. To do otherwise invites further incompetence from one of the most important agencies under our jurisdiction and sets a dangerous precedent for other agencies under our purview. I'd like to yield the balance of the time to the gentleman from Virginia, Mr. Griffith.
Thank you, Dr. Burgess. Last fall's fungal meningitis outbreak was a true public health crisis for our nation. In Virginia's 9th Congressional District, which I represent, there were 2 deaths and 50 confirmed cases of fungal meningitis associated with the sterile compounded injections from NECC. Approximately 1,400 patients in Southwest Virginia were notified they could have been exposed to fungal meningitis because they received tainted steroid injections. I clearly believe that FDA had the authority they needed to prevent the fungal meningitis outbreak. NECC was a manufacturer. The committee's thorough investigation has demonstrated the agency failed in their oversight and did not pursue regulatory action against NECC and Ameridose, who were acting illegally as manufacturers, not as compounding pharmacies, in violation of the Food, Drug, and Cosmetic Act. With well over 130 community pharmacists providing invaluable access to health care in rural and remote communities in the mountains of Southwest Virginia, I do not support giving FDA broad new authority over the practice of pharmacy, which is the jurisdiction of our states. The type of compounding that goes on in our local pharmacies involves making special medications subject to the needs of the individuals based on a patient's specific prescription from their physician. The real problem is large-scale operations like NECC who are acting illegally as drug manufacturers by making large batches of drugs, some of which are just copies of FDA-approved drugs, and then selling and shipping them all over the country. In her testimony, Dr. Woodcock acknowledges that FDA was in the final stages of publishing new guidance differentiating pharmacy compounding from drug manufacturing. 3 years later, FDA finally had all of its ducks in a row and was ready to go forward, but they did not do so in their draft guidance document. I believe there are some areas that need clarification, so we have been doing our due diligence to understand this issue and develop legislation that will make it clear how we define what a compounding pharmacy is, which is and should be regulated by the states, and what a drug manufacturer is, which should be regulated by the FDA. Yield back.
Chair, thanks, gentlemen. That concludes our opening statements. We have two panels today. Our first panel today, we have Dr. Janet Woodcock, Director of the Center for Drug Evaluation and Research, U.S. Food and Drug Administration. Thank you for coming, Dr. Woodcock. You will have 5 minutes to summarize your testimony, your entire written testimony we place in the record. You're welcome and recognized for 5 minutes.
Thank you, Mr. Chairman, Vice Chairman, Ranking Member, and members of the committee. Thank you for the opportunity to testify. This has really been an appalling tragedy of a kind not seen really since the early 1900s, where American citizens were harmed by grossly contaminated drug. But this is just the worst of a long series of outbreaks over the past 2 decades that have involved compounding pharmacies. And these have included multiple deaths, blindness, hospitalizations, and other types of harm. So this was just the worst of a continuing series of outbreaks. As the Commissioner testified, we should have been more aggressive in applying our existing authorities to this industry, despite the ambiguities in the statute and despite challenges by industry. We are being more aggressive now, and we are inspecting the pharmacies that we know about that present the highest risk. And we're seeing really serious systemic quality issues, particularly around sterility practices. In light of recent events, though, even with the tragedy that has occurred, some of these firms challenge our authority when we try to go in and inspect them. And they delay or deny full access to our records. We've twice had to get administrative warrants from the court and have U.S. Marshals accompany our inspectors. And we've had to threaten warrants in other cases to get cooperation to inspect these compounding pharmacies. And because we're inspecting and moving aggressively doesn't mean we're going to prevail in court. Make no mistake, if the approach to this isn't changed, and I think legislation is probably the best approach, we will see more of these tragedies. We are already, since the outbreak, we have seen several episodes involving human harm from compounded products. Lack of clarity in our statutory authorities really isn't the only concern. The industry has evolved tremendously since the time of the corner pharmacist and traditional compounding in response to a prescription. And this is still going on, and FDA has always said we felt this was appropriate. But another industry has grown up that's basically performing outsourcing for hospitals and making large amounts of dosage forms, often starting with FDA-approved products. And this industry was really never contemplated in the kind of authorities that we have. So we feel that we need legislation to preserve the benefits of traditional compounding, which is in response to a prescription, and which we are not proposing that we should have authority over, further authority over, while at the same time giving us the right tools to regulate high-risk practices and products. And what we feel we need legislation that requires compliance with federal quality standards, requires federal registration, because right now we don't know who they are, we don't know where they are, and we don't know what they're making. And requires reporting to FDA of adverse events so that we can act before the problems get out of hand. Right now there's no requirement to send us reports of death or other harm that might occur with these products. And for all pharmacy compounding, we feel basic protection should be in place, including the fact that FDA should have access to the records so that we can go in and see whether they're shipping large amounts of product, all right, and what they're doing. And also, should there be an outbreak, we are not delayed by having to go to a marshal and have access to the shipping records. A prohibition on compounding the most complex and highest risk products. Our drug manufacturers, as you know, have problems manufacturing certain products because they're very complex. And they put a tremendous amount of science and effort into that. We don't think they should be compounded. That's a small list, but we think that list should be maintained. And clear labeling of compounded drugs to allow prescribers and patients to make more informed choices. We look forward to working with you to explore funding mechanisms to support this oversight should it be put in place. Remember, I think it's really not a matter of, it really is a matter of when this is going to occur the next time, not if. That is the state that we are observing of the industry when we're inspecting them. We are all on notice. We owe it to the public and the victims of this incident and the numerous outbreaks over the years to provide better protection in the future. I look forward to answering your questions.
Thank you, Dr. Woodcock. I'll begin the questioning and recognize myself 5 minutes for that purpose. Dr. Woodcock, since the outbreak, the FDA has executed dozens of inspections, and at least 11 companies were ordered to stop producing some or all drugs. Have any of the companies you inspected challenged the FDA authority? If so, how many?
Certainly, as I said, we've had several challenge our authority to even go in the firm and look at the records, right? Others have challenged and then yielded when we got the lawyers talking to one another. Now, as far as whether there'll be court challenges, that's something I really can't speak to, but that certainly has been the history in the past.
Can you provide a list to the committee of the companies who you've inspected and who've challenged your authority?
We'll be happy to do so.
Thank you.
That involves.
According to the Senate Help Report, I quote, as a result of increased oversight from both state and federal regulators, at least 48 compounding companies have been found to be producing and selling drugs that are contaminated or were created in unsafe conditions or otherwise violate state licensing requirements. 10 companies have issued nationwide recalls of drugs compounded at their facilities. In at least 4 cases, the recall was issued in response to documentation of actual contamination. Further, 11 compounding pharmacies have been ordered to cease and desist operations, including 2 of those that had issued nationwide recalls. Now, as you said, some of these companies challenged the FDA's authority. Can you explain how state and federal regulators executed this increased oversight?
Well, we identified firms that we knew about, basically from adverse event reports, from reports in the paper, from advertisements they had on a web page and so forth, and we did a risk-based approach to inspecting what we felt were the highest risk firms based on what we knew. We don't know the whole universe of firms that are out there. We also continue to do for-cause inspections. For example, if we get a report from a health department about a cluster of cases, of an outbreak of one sort or another, we will immediately go in to that pharmacy and inspect them. In all those for-cause cases, we've gone in with the state authorities. So we've gone in together, all right? And in most of the other inspections that we did, that we planned, the 31 inspections, we've gone in with the state authorities as well.
What were the biggest challenges that you faced during that period?
Well, the challenges mainly were getting access in some cases to be allowed to inspect, all right? Particularly some of their records. But the real thing that we have found is that the aseptic processing practices, which means how you try to make a drug to ensure that it is sterile, are not anywhere near the quality that is necessary to mass produce sterile drugs. There's a tremendous deficit of quality in their practices that almost assure that these drugs will at some point be contaminated.
What are some of the lessons the agency has learned during the period of this outbreak?
Well, I think we have learned that there are pervasive practices that are unsafe that are going on across the portion of this industry that we have investigated. Primarily, we are targeting those sterile manufacturers because that's the highest risk when you're actually injecting drugs into the body. So that's one thing we've learned is a pervasive nature of unsafe practices across the section of industry that we have inspected.
Now, in your testimony, you referenced 9 separate incidents where compounded products caused deaths and serious injuries. Explain briefly the actions the FDA took following each of these incidents.
Well, over the years, our actions have been primarily reactive, okay? So when we have learned of an outbreak, as I said, we have gone in. Often we go in with the state. The state, because they hold a pharmacy license, they're able to shut down the firm right away. Like that's how those 11 firms you referred to were shut down, okay? We have to call for, and we often do, talk to the firm and say, we're going to go to the press if you don't do a recall. Because we don't have the authority to, they don't hold a license with us, so we can't just shut them down. We would have to then go to court if they still refused to shut down their operations.
My time has expired. Chair recognizes the ranking member 5 minutes for questions.
Thank you. Dr. Woodcock, your testimony mentions the various court challenges that the compounding industry has brought over the years regarding FDA's authority over compounding pharmacies. But I'd like to learn more about that litigation and the impact it has had on FDA's ability to oversee the industry. Those cases center around Section 503A of the Act, which was enacted as part of the 1997 FDA Modernization Act. And that law attempted to delineate when compounded drugs were new drugs and therefore subject to FDA regulation. Section 503A also restricted compounding pharmacies' right to advertise. So I'm going to put a map of the U.S. up on the monitors here. It's up there. This map was not prepared by me or my staff. It was actually prepared by the International Association of Compounding Pharmacies, the main compounding industry lobbying group. On this map, the red states and blue states do not represent states that voted Democrat or Republican. They represent the different rules under which compounding pharmacies operate. So let's look at the red states. Those represent the Ninth Circuit Court, whose jurisdiction includes the western states. And as IACP notes on this chart, in 2001, the Ninth Circuit Court ruled that the advertising component of Section 503A was unconstitutional and that the rest of 503A was void because it was inextricably tied to the advertising component, or that it was not severable, as we say. Is that correct?
Yes.
Okay. Then in 2002, the Supreme Court agreed with the Ninth Circuit that the advertising ban was not constitutional, but the court did not address the question of whether that ban could be severed from the rest of Section 503A. The result of that decision, then, was that the advertising ban was unconstitutional throughout the country, and the entirety of Section 503A remained invalid in those red states on the map. The Supreme Court decision also meant that whether the remaining parts of Section 503A was effective in the rest of the country was an open question. Is that your understanding?
That's my understanding.
So let's look now at the blue states on the map, Texas, Louisiana, and Mississippi. Those states represent the Fifth Circuit. 2008, the Fifth Circuit Court of Appeals held that the unconstitutionality of the advertising restrictions did not affect the standing of the rest of Section 503A. So that means that in Texas, Louisiana, and Mississippi, Section 503A is in effect. Am I correct on that?
That's my understanding.
And am I correct that the gray states on the map then represent the rest of the country where we just don't know how courts would rule on whether Section 503A, apart from the advertising restriction, is or is not in effect? Can you tell us what the impact of this 503A patchwork has been on FDA's ability to oversee the compounding industry? Have compounding pharmacies been able to take advantage of this confusion over the law to block FDA's ability to aggressively enforce the core authority it does have over compounders?
Yes, I think that definitely contributed to the inability of FDA to have an effective regulatory program. All right, we have different circuits with different meanings of the statute that was passed by Congress in 1997. In some areas, the statute is thrown out. In other areas, it's partially operational. In other areas, we don't know if we went to court what type of decision we would get.
So this seems to me to be all that we as members of Congress need to see to understand the dire need for clarifying the FDA's authorities here. And I'm hearing from, what I don't understand is I'm hearing from the GOP here on the committee that they don't seem to want to give the FDA any additional authority, even though the Senate passed a bill on a bipartisan basis that does. And yet, I don't see any alternative. In 97, for better or worse, Congress spelled out FDA's authorities over compounding pharmacies. I think that law is out of date and should be updated. But putting that aside, courts have invalidated that statute, our statute, in a major swath of the country. I think it's irresponsible for us to stand by and expect FDA to cobble together a piecemeal approach to regulating the practice of compounding pharmacy, a practice that, as evidenced by the NECC, bears great risk for patients all over the country. I don't quite understand why my colleagues on the other side, at least here in the House, not in the Senate, don't want to step in and clarify the rules of the road. I think we have to do that. Otherwise, we're going to continue to have these problems with compounding pharmacies. And I hate to say anything positive about the Senate, but they're moving in that direction, and we need to do the same. Thank you.
We are presently voting on the floor. We have 2 votes. We will recess until the second vote is over, and then reconvene. We'll have another series of vote around noon. So if you can stay, Dr. Woodcock, we'll recess at this time for floor votes and be back as soon as the members finish their second vote. Time of our recess having expired, we'll reconvene and continue our Q&A session. Chair recognizes the Vice Chair of the subcommittee, Dr. Burgess. 5 minutes for questions.
I thank the chairman, and thank you, Dr. Woodcock, again for being here. So between 2002 and 2012, according to our investigation on Oversight and Investigation Subcommittee, the New England Compounding Center was the subject of at least 52 adverse event reports. Numerous offenses documented throughout the investigations undertaken by both FDA and state regulators. So, the big question is, why not do something? Why not take action? And tell you the truth, it was a little hard to read through some of the emails that we finally got. Your folks were literally pulling their hair out about what we can't just send another warning letter. We've already sent one, to which it took us 2 years to respond, and we'll have to do something. And it was like they got right up to the point of having to do something, and then no one wanted to do it. Is that an unfair assessment?
Well, I'm unable to comment specifically on NECC because of the ongoing criminal investigation. However, generally, I would say we should have been more aggressive overall in this industry. There was a pattern for many firms that we were looking at of adverse events, and as I said, there were a series of outbreaks. Every year, practically, we would have an outbreak due to contaminated compounded product. And we should have been more aggressive in going after this industry.
Well, again, I just don't understand, some of your folks, they just had to be losing their minds over this stuff. Samia Nasser name kept coming up in the emails that were provided to us. Does she still work at the agency?
Yes.
Well, I know you can't comment on employment, but I mean, I think she did the right thing to bring all these things to people's attention, but it must have driven her crazy that the people just above her wouldn't do something.
As I said, overall, we should have been more aggressive as this industry continued to be responsible for outbreaks. We investigated outbreaks, we investigated reports, and we did respond reactively to problems, but we did not proactively do everything we could.
And as a consequence, you had 50 deaths and 500 people who are living with long-term disability as a consequence of the X-serohylum in the betamethasone.
Well, we have more people who have died than that. We have people who have been blinded. We have people with disabilities as a result of these outbreaks over the last 12 years. And I would say, frankly, if you want my opinion, that we could have done more, the states should have done more, and Congress could have intervened when these statutes were struck down.
The ranking member had a nice map up there, and he made a nice little comment about red and blue states. But honestly, the 503A limitation doesn't affect Massachusetts at all. I mean, we're talking about Texas and California, Fifth Circuit, Ninth Circuit, but Massachusetts is outside that. So what prevented you in Massachusetts?
As I said, I can't specifically discuss this particular case because of the ongoing investigation.
Well, okay. Let me ask you this. How difficult is it to get an injunction from a judge? You go to a judge and say, we've got a problem here. How difficult is it to get an injunction?
As I understand it, I'm not one of the agency lawyers. I'm a physician, as you know. But we make a recommendation to the Justice Department, who then proceeds to do the legal activities. And just because we initiate legal action doesn't necessarily mean we will prevail in court.
How many times have you not prevailed?
I don't know. We can get back to you.
Would you get us that information?
Absolutely.
Out of all of the challenges that you've submitted to companies, how many have actually stood up to you and said, we don't want to do it?
Certainly. I think there are, we do bring our cases that have the best facts, all right, to, as we sort through the cases, we put forth those that have the best facts that we would be most likely to win.
Well, again, it's just so frustrating to think that the guidance that supposedly was going to come out, that was going to solve this problem, just really seemed to be enmeshed in the bureaucracy for 3 years. Is that a fair time length?
I think that's fair. However, that was trying to make the best of a bad situation. We do not have the tools that fit this industry, right?
And I disagree, because do you not have power under the Food, Drug, and Cosmetic Act
Yes.
to regulate manufacturers?
Yes.
Do you define manufacturers? I mean, if someone's making 30,000 vials of stuff a month, is that a manufacturer?
Well, say if I am Janet, the pharmacist, all right, and I have a pharmacy that's licensed in a state, right, and I am compounding drugs, right, and then I decide, well, I want to broaden my activities, and my state allows anticipatory compounding, and my state allows office stock, right? So I can compound those in advance of or without a prescription and send them. And there's no...
30,000 vials a month.
There's no... What is the number? That's the thing we've been struggling with for 12 years. Is it 10 vials? Is it 1,000 vials?
Well, let me ask you this question.
There's no volume limit in the statute. Excuse me for interrupting you.
Well, Massachusetts Board of Pharmacy fired people. Is the Food and Drug Administration going to let anyone go?
No.
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 I yield back, Mr. Chairman.
Chair, thanks, gentlemen. Now recognize the gentlelady from Florida, Ms. Castor, 5 minutes for questions.
Thank you very much. I wanted to get just to that point. Where do we draw the line? Where is, because I think as legislation is developed, and your testimony is that you do not want, and it's not appropriate to capture the community pharmacists who are compounding.
That's correct.
And that's not the source of problems. So where do you recommend the dividing line should be? What is the criteria in law? Has the Senate addressed this in their bill? Where do they carve out so that the community pharmacists that are compounding are protected, and others that have exceeded that and are really the large-scale manufacturers? How do we develop that criteria?
Well, the Senate is attempting to set forth a framework, and we feel they're going in the right direction. But those clear lines between who is a drug manufacturer, who's a traditional compounder, and who is the new category of compounding manufacturing, we still feel are not clear enough, so that we could have people masquerading, and some of the other witnesses I think are going to talk about this if my reading of their testimony, okay, that we could have people masquerading as traditional compounders or as compounding manufacturers who really were competing with the generic drug industry or the innovator drug industry, and actually should have sent us applications and paid a user fee and gone through the established process that we've had in the United States since 1962. And so that's really the issue, is how do you draw those boundaries?
And what are your recommendations then?
Well, what we had proposed is that we pick off the highest risk category, which is those sterile products that are shipped interstate, all right? So they're shipped around the country. That's probably the highest risk, because the longer you store the sterile product, the more likely, if they're contaminated, that there'll be growth that can grow up. And obviously, sterile products are a high risk. And interstate is one sort of marker for volume. And this industry that's grown up, the outsourcing industry, is valuable to the hospitals. We've heard from the hospitals. They feel they can't do without these folk. And they generally take FDA-approved products and they mix them, or they put them into convenience dosage forms. If you've gone to a clinic in an office building and you've had a procedure, you may have received product from one of these firms that put you to sleep or whatever, and they package them, say, in syringes and so forth, and send them to these various clinics and also to hospitals. We feel that type of industry, they produce in pretty high volume, and that's the highest risk, and they should have full aseptic processing controls, just like the regular drug industry does. So we agree with carving them out and having certain requirements for them, but not submitting a new drug application, having to pay a user fee, and going through that entire process.
So highest risk, crossing
State lines.
Sterile products.
Right.
You recommend. And then to clarify your last part regarding what if it's a compounding that's going to hospitals within a state?
Well, what we had proposed is that would be regulated by the states. The states could decide whether they have the capacity to do that. I think you may hear from some of the other witnesses that, in fact, that type of compounding, especially at volume, because it's the mass production that really increases the risk, both the risk of contamination and the consequences of contamination once it occurs, because it goes to so many people, right? And the risk is there for intrastate, but the states, we feel, could decide whether they would regulate those type of activities or not permit them, right? And then the traditional compounding is really where, a doctor, and I have done this too, all right, a doctor writes a prescription to a pharmacy and asks them for an individual patient who has a specific need, to make a dosage form that isn't available commercially, because they have a very specific medical need for that. We feel that should be preserved, but a box should be put around it, and there shouldn't be competition with established generic products, because there's always more risk than for a regular product, for any of these compounded products.
Okay, thank you very much.
Chair thanks, gentlelady. Now recognize the Chair Emeritus of the full committee, Mr. Barton, for 5 minutes for questions.
Thank you, Chairman Pitts. I am very troubled, Dr. Woodcock, by your opening statement. I do give you credit for integrity and honesty and forthrightness, but you ended up saying that it's not if this is going to happen again, it's when it's going to happen. That's pretty strong. We're talking about people dying. And I have attended, not in their entirety, but I've attended every hearing that we've done on this issue with NECC, and it is not that Republicans are not willing to regulate. It's not that we're not concerned. It's that we do think there is a true state-federal partnership, and we do think that state regulatory authority is as good as federal if it's within the state. And we don't see a reason to preempt the states unless the states either can't do it or won't do it. And what struck me in the answers to Dr. Burgess's questions was, at some point in the process, anybody at the FDA could have picked up the phone and called the state regulatory authority, and apparently never did. Now, I don't understand that. If you really believe that what you said is true, that it's not if it's going to happen again, it's when it's going to happen again, if you have a list of compounders that you think are problematic or in danger of actually endangering human life, if you really think the FDA doesn't have the authority to shut those people down or make them clean up their act, you have an obligation, or somebody that's designated by you, to call the state regulatory authority to inform them of the problem and to take whatever steps necessary to make sure that the state does. Now, why haven't you done that? Or why haven't people at your agency done that?
Well,
That's what I don't understand.
We have done that more recently, and we have, as I said, we have worked hand in glove with the state authorities. We've done joint inspections with them. They have taken the steps to close down many of these pharmacies after the inspection, and we are sending them our findings. We send them letters. We post our 483s, which are our findings of the inspection, so that they're available to the public, and we work very closely with the state authorities. However, there are 23,000 compounding pharmacies in the United States, according to the industry. They don't have to tell us who they are, and they don't have to report to us if they have problems. So we are
They can't operate if they don't tell you or don't tell the state. You're not telling me there are 23,000 compounding pharmacists that are operating out in the ether and that are not subject or not licensed by somebody.
They are licensed by states. They're licensed pharmacies. And I read a report by some of the members who looked at what amount of control and tracking the states have over the different pharmacies. And many states do not have a lot of understanding of what activities those pharmacies are engaged in, particularly whether they're shipping to other states and so forth. So the state, different patterns in different states, but not all states really have close control over what those pharmacies are doing as far as compounding.
Well, there is the witness that's in my district, Mr. Harmison. I have been in his pharmacy. I mean, he's the true small independent businessman. He's got a compounding room, I think 1 or 2 rooms, and has 2 or 3 pharmacists, including himself. Now, I've also been in other compounding pharmacist situations in Texas where they have 10 or 15, and it's much more of a mass production type situation. So there is a difference. But the FDA, in conjunction with the states, should be able to determine who has jurisdiction and what needs to be done. I don't think Mr. Pitts or Mr. Upton or any of the Republicans are unwilling to sit down and help clarify, to use your term, what needs to be done. If there truly is a gap, and it truly is best to regulate it at the federal level, I would say that the Republicans are open to it. But if it's simply a question of communication between the federal government and the state regulatory authority, I would encourage you to facilitate that communication, because I don't want if to become when.
Right. Well, we had a 50-state meeting. We've been in close contact with the Association of National Boards of Pharmacy. So we're talking to them twice a week. We're talking to all the state boards in the states where we go in and have these inspections. And as I said, we do the inspections with them. We've heard from many states that they would prefer federal regulation of these larger scale facilities. But the real question here is, and has always been the question, is where to draw the line. All right, so you have the traditional pharmacists. They're writing, they're compounding in response to a prescription. I, as a physician, I have written prescriptions for compounded products that were very valuable to my patients. That's one. All right, and you mentioned, okay, then there's somebody, if they have 5 rooms.
My time has expired, and the chairman's been very gracious. We can work on helping define and helping to clarify. I think there's a bipartisan trust on this committee and this subcommittee that can do that. If you and the stakeholders will begin to communicate with each other, I think this is a solvable problem. But it's not necessarily the answer. It's going to be more federal regulation. It may be, but it's not automatic that it will be. And with that, Mr. Chairman, thanks for your time, and I yield back.
Chair, thanks, gentlemen, and now recognize the ranking member emeritus of the full committee, Mr. Dingell. 5 minutes for questions.
You are most courteous. Thank you, Mr. Chairman. I ask unanimous consent to insert 2 letters which I wrote to FDA on this matter in the record.
Without
as
objection,
well as
so ordered.
Responses from FDA, and I thank you, Mr. Chairman. Now, these questions will be mostly yes or no. Does FDA have the authority to require all compounding pharmacies to register with the agency?
No.
Yes or no?
No.
Please submit for the record the new authority that you need. Next question. Does FDA have the authority to require all compounding pharmacies to report adverse events?
No.
What authority is needed? Submit for the record, please. Does FDA have the authority to require all compounding pharmacies to follow good manufacturing practices? Yes or no?
No.
What authority is needed? Submit for the record. Question 4, does FDA believe non-traditional compounders should be subject to appropriate good manufacturing practices the way manufacturers are? Yes or no?
Yes, as appropriate.
What is the authority which is needed? Submit for the record. Does FDA believe risk-based inspection schedules are appropriate for non-traditional compounders? Yes or no?
Yes.
What authorities do you need to achieve that end? Submit for the record. Does FDA have full authority to see all records when inspecting a compounding pharmacy? Yes or no?
I think that's being contested.
Yeah,
So no.
You have that problem between the different circuits.
Yes.
Please submit to us what authority is needed. Does FDA need additional authorities in these areas to ensure that outbreaks of the kind we have seen does not happen again? Yes or no?
Yes.
Yesterday, my colleagues, the Senate advanced bipartisan legislation giving FDA more authority over compounding pharmacies. It's my hope we in the House will do the same thing. I've long believed that we must provide agencies like FDA with clear authorities and necessary responses to properly help and carry forward their mission. FDA has a fee system for the approval of pharmaceuticals and medical devices, amongst others. Please inform us whether you need that kind of authority for purposes of the record. Now, if we give FDA the authority in this area, and I believe we should, we will also, I believe we also should have a strong user fee program. Would you submit for the record some information justifying such thing if you believe that is appropriate, Doctor?
Yes.
Now, would the user fee contained in the Senate bill provide the FDA with the necessary resources to carry out these new authorities? Yes or no?
Partially, 50%.
Okay. Now, I got just a little bit of time left. I am reminded of the situation we have here. We got people being killed because we have unclear authorities. We have a responsibility to see to it that we clarify that as a part of our oversight responsibilities. There's a great joke that they tell about a fellow who got a letter from an undertaker saying that his mother-in-law had just had a stroke and passed on. And he asked for instructions. He said, should we cremate, should we bury, or should we embalm? And the guy thought for only a second, and he sent back a telegram saying, do all three, take no chances. Now, I think here we got a problem where people are being killed by a dichotomy in the industry. And doctor, I want you to tell me, you have roughly 3 classes of compounders, right? You got essentially the manufacturing compounders who ship all over the country, huge volumes, right?
Correct.
You don't have very clear authority over them, do you?
No.
And the states don't have the resources to do it, do they?
That's been documented.
Okay. Now, having said that, you also have the ordinary pharmacies. We're not particularly after them, and they are supposed to be regulated by the states. They're licensed by the states, and they are identified by state regulations to the states, right?
Yes, we believe that traditional practice of pharmacy compounding should be preserved and regulated by the states.
Okay, now, then we have the additional situation where you have the hospitals, and they have either in-house or they have people who contract with them to compound to meet the specific needs of patients in the hospitals, right?
Correct.
What authorities you need there?
Well, we believe that the hospitals could operate under the regular rules of pharmacy. These are hospital pharmacies that are licensed by the state and also regulated by other authorities. We believe that outsourced contractors should be regulated under the compounding manufacturing.
Okay, so here now you have a muddled situation where the courts are getting in and assisting us to confuse an already obfuscated situation. And we need to do something to clarify it. And since the great events in Michigan, where a bunch of my constituents and others were killed, we have seen that the compounders have continued their same merry practices of disregarding the law and proceeding to send noxious compounds around that are compounded in unsafe atmospheres and climates. Is that right?
We have seen since the outbreak.
Yes or no?
Yeah. Yes.
Mr. Chairman, I have used 44 seconds too many. Thank you.
Chair thanks the gentleman. Now recognize the gentleman from Virginia, Mr. Griffith, 5 minutes for questions. Mr. Griffith, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, Dr. Woodcock. I'm looking at your draft, not for implementation, report on pharmacy compounding that was done in August of this year, and I want to clarify this court issue. Disagree with me and tell me yes or no. I'll ask you at the end of each part of this. But it appears that in April of 2002, based on this report, and I believe it to be correct, that the U.S. Supreme Court affirmed the Ninth Court's decision related to advertising and solicitation, but did not take up the severability as to whether or not the rest of the act would be in place after that date. Is that correct?
My understanding, yes.
And is it also correct that the Fifth Circuit found it was severable, and that decision was came out in 2008?
Correct.
The FDA took no action. Am I correct? The FDA took no action to clarify the law between 2002 and 2008 when the Fifth Circuit came out with their opinion. Isn't that correct? Yes or no?
Yes.
And it would also be correct that from 2008 until the incident with the fungal meningitis, the FDA never came to Congress and said we need clarification. Isn't that true? Yes or no?
Yes.
And isn't it true that you were working on these draft guidelines because you believe there was a way to figure out around the court decision issue and regulate to the best of your ability, with the Ninth Circuit being a little more difficult, but that's why you worked on these guidelines for over 3 years. Isn't that correct?
As I said, we were trying to make the best of a bad situation.
Wouldn't the right thing to have done to come for clarification on the severability and just reenact the old law and take the advertising section out? The only part that any court said actually violated the Constitution and the whole issue was severability. Wouldn't that have been the better thing to do from 2002 until 2012?
Yes, I think in retrospect that would have been better. I think there was a fear of getting a
Was there a fear of coming to Congress and asking for help when you needed it?
Well, you know, the late Senator Kennedy did develop a bill and ask around about it with some other senators, and there was so much opposition that they never introduced that. And I think
Did the bill do anything other than clarify that the bill could be severed and that the only parts that weren't in place or should be in place were the advertising restrictions?
I'm not familiar with what exactly.
Okay, because I don't know what was in that bill, and I suspect there was something other than clarifying the law in there. And I would have to say in the draft guidance that you all were about to propose, the FDA described a new framework for compounded drugs that would be administered in a healthcare setting. And basically what you proposed was that you could compound for more than one patient in the hospital setting or in a medical practice setting, as long as there was a prescription that followed. If you knew you were going to use it like in an ophthalmological setting or in a hospital setting, as long as you could tie that later to a direct patient. Isn't that correct?
That's my understanding.
And so under that reading of that, other than clarifying that the advertising section is no longer the law, you really didn't need any new authority to do that, did you?
To make that
Yes or no?
interpretation.
To make the interpretation.
I don't understand your
it's in your
question.
guidance request, so I assume that's correct. Is that correct?
That's correct.
Okay, and I appreciate that. And I'm looking up to see how much time I have left. We also have this business about talking to the states. There's nothing that prohibited you in the law from talking to the states when you got complaints from, say, Colorado or Ohio, which actually happened in the NECC case. Nothing prevented you from calling Massachusetts, did it?
No.
And in fact, in the guidelines, you're setting up a new way to make that work so that it's efficient. Isn't that correct?
The guidelines.
The guidelines of sharing information between the states and making sure that everybody's keeping an eye on
the guidance
these folks. The guidance, yes, ma'am.
Mm-hmm. Yes.
And so you didn't need any new authority to do that, did you?
We don't need new authority to talk to the states. We do that all the time in many different areas of regulation.
But you failed to do that in the NECC matter. And I guess my concern is that while I, too, have learned to respect your veracity and think you're a great witness, much better than that other lady that came in here. You know, we couldn't get anything straight out of her, so I do appreciate it. But I would have to say that, you know, one of my concerns is that the FDA had all these tools available to it if it had chosen to do so. And I understand in retro, people make mistakes, things happen. I understand that. I'm not being critical. But instead of asking for new authority, shouldn't we just clarify the fact that the advertising restrictions aren't the law, and that if there's areas that need to be clarified, not giving new authority, but just clarify some things, that we could follow your guidance proposal from August of last year and come up with a pretty good proposal. Isn't that true? Yes or no?
No, I don't
So
think
that was a bad proposal that you all were putting guidelines out on?
The guidance.
Yes or no? Were those guidance proposals bad?
They were based on the 503, which is not really that workable for the current industry that we have. Sorry, I can't give you just a no answer.
All right.
I
So
don't
if
think
you
we
could
have a good.
I'm out of time, so if you could submit your recommendations, I would greatly appreciate it. Mr. Chairman, I yield back.
Chair thanks the gentleman, and now recognize the gentleman from Texas, Mr. Green. 5 minutes for questions.
Thank you, Mr. Chairman. Dr. Woodcock, thank you for being here today, and I'm concerned that the majority side has looked at this issue and said the FDA has the necessary authority to properly regulate. As Commissioner Hamburg explained at last meeting, the current level of scrutiny being applied by the FDA is a result of the outbreak. Their court case may be strengthened, but its favorable ruling on the authority over compounding manufacturers or non-traditional manufacturers is far from certain. As a result, I think we must pass limited legislation that allows the FDA to regulate compounding manufacturers across state lines. The draft currently being debated in the Senate is a good first step, but I think there's some changes that we'd make to strengthen the bill. In her testimony before the committee, and I won't judge on Commissioner Hamburg's testimony, asserted the agency needs greater authority over large compounding pharmacies that are essentially manufacturers. The Senate legislation would create a new category of compounding manufacturers that would be under FDA regulatory authority. Commissioner Hamburg also told us that the FDA agrees that the regulation of a traditional pharmacy compounding should be left to the state legislatures and state boards of pharmacy. We have laws in my home state of Texas that allow, when medically necessary and in very limited circumstances, the compounding of medications before the receipt of a patient-specific prescription. For administration in the office of the prescribing physician, they're also called office use compounding. It's my understanding that a majority of states have these similar laws. Dr. Woodcock, what do you recommend that Congress craft, or how do you recommend that Congress craft language to give the FDA the necessary authority to regulate large interstate compounding manufacturers while still preserving the ability of states to regulate the traditional compounders?
You know, it's a complicated question. We want to make sure that the traditional compounders can flourish because they provide a valuable service, but not that they don't go to 20 rooms or 50 rooms, right, and start making large scale. So there have to be boundaries there. Traditional manufacturers obviously have to submit applications to FDA, pay user fees, and then undergo review and frequent inspections for GMPs. The hospitals have told us, the hospitals in your district and all around the country have told us that they rely on this industry now for the compounding manufacturing industry, if you wish to call it that, for certain services that used to be done in the hospitals but are now outsourced. However, these operations are proceeding under the rubric compounding right now, but they're doing something quite different at a larger scale. And so if Congress would see fit, what we're saying is not we want more regulation, we want regulation that would fit this new activity, right, and would be appropriate for that and allow them to flourish.
Because I only have a couple minutes left. For example, if a hospital in Houston wants to contract with a company in Massachusetts,
right,
that still should be under FDA authority.
For sterile products is what we're proposing. So if they want to get injectables from a New Jersey firm, they want to buy injectables and use it in their hospital or in their clinics, we think that should be under FDA authority if those are sterile products.
Okay. Do you agree that legislation should clarify the current law in the area and protect the ability of states and boards to decide what's the appropriate scope of practice for traditional pharmacies?
Absolutely.
Including the areas of anticipatory and office use compounding?
Well, we have to make sure that it draws the line and doesn't allow them to produce, say, and how do you do that? As 17,000 vials, is that anticipatory compounding?
Yeah.
have to have some clarity on that.
It seems like it would be. What is the FDA's position on office use compounding pursuant to state law where it occurs? Under the current federal law, FDCA, and under the legislation being considered in the Senate?
Well, right now, under current federal law, it is blurry, all right, as far as how much you could make. You all are saying to me that you think you can tell what a manufacturer is, but there is no bright line in the statute that says when you cross that line and become a manufacturer.
And that's our job to define that.
That would be very useful.
The other thing I'm concerned about, traditional compounder in an area that's close to state boundaries. Again, in Massachusetts with New England, there's maybe a different problem, whereas in Texas, it's not that big a problem except on our border with other states. How do we keep those traditional compounders being classified if they work across state lines geographically fairly close from being classified as a compounding manufacturer?
Well, we think there are some federal standards that ought to be in place, okay, that distinguish even the traditional compounder, so that there are certain things that they are held to do, and then they remain traditional compounders.
Thank you, Mr. Chairman. I appreciate it and look forward to working on the legislation.
Chair, thanks, gentlemen. Now recognize the gentleman from Pennsylvania, Dr. Murphy, 5 minutes for questions.
Thank you for being here, Dr. Woodcock. I have the highest respect for you, and I appreciate your candid conversations. I want to cut to the chase here because I don't want this to be a political discussion. I think it's being mislabeled as that. I held hearings in my subcommittee on oversight and investigation, and it was my impression we weren't getting clear answers about missteps within the FDA. And I just want to make sure that I know that the FDA is saying, we've learned from our problems, and here's how we change. So let me run through a series of questions with you and help get that on the record. First of all, the FDA has repeatedly cited the fact that the Fifth and Ninth Circuit Courts of Appeals have issued conflicting decisions on whether Section 503A of the Food, Drug, and Cosmetic Act remains valid. And in a written statement on November 14th of last year, Oversight Committee hearing, Commissioner Hamburg cited the Circuit Court split as having, quote, amplified the perceived gaps and ambiguity associated with FDA's authority over compounding pharmacies, unquote. Now, the Fifth Circuit Court decision was July 2008, is that correct? In May 2009, just prior to Commissioner Hamburg being confirmed, a briefing was provided to Acting Commissioner Joshua Sharfstein, proposing several paths forward in light of the Fifth Circuit's decision upholding 503A. Do you recall participating in that briefing, yes or no?
No.
Okay. The FDA produced to the committee an email chain from within the Office of the Chief Counsel from July 2009. A copy of this document, I think, is now in front of you. The top email is from Michael Landa, FDA's acting chief counsel at the time, and notes that the plan is to enforce Section 503A nationwide, except in the Ninth Circuit, and that, quote, Josh is on board, unquote. Mr. Landa then notes that Dr. Sharfstein, quote, would touch base with Peggy, but did not think she would have any objection, unquote. Do you know whether or not Commissioner Hamburg was consulted in the decision to proceed with enforcement of Section 503A?
I do not know affirmatively, no.
Okay. Do you suspect that she did, or you're...
I would suspect that she was.
Thank you. And if you turn to the second page of that email chain, the leader of the compounding team in FDA's Drug Center, your center notes that Dr. Sharfstein and Deb Otter asked to chart the time frame for each step we plan to do to implement the new plan. Dr. Woodcock, this plan has yet to be implemented when the outbreak began in September 2012. Am I correct?
That's correct.
And yes or no, prior to announcing the new plan, FDA felt as though it needed to draft a new guidance document detailing the approach it would be taking, as well as various regulations that 503 required. Yes or no?
That's my understanding.
Thank you. And yes or no, during this time period, inspections and enforcement actions came to a standstill?
My understanding is that is not true, that we did certainly went for cause inspections.
Certainly with NECC.
I can't comment specifically on NECC, I'm sorry.
Is that something
due to the ongoing criminal investigation.
I understand. By August 2012, your center signed off on the draft guidance document. It was going through final clearance. Yes?
Yes.
Or no? Okay,
That's
thank
my
you.
understanding.
And a briefing has been had, in fact, been scheduled to discuss the new guidance documents with Commissioner Hamburg back in September 2012. Is that correct?
That's correct.
And yes or no, Commissioner Hamburg testified before O&I that she was really not that aware of issues related to drug compounding until after the meningitis outbreak. Therefore, would any additional changes to this draft guidance document have been made based on Commissioner Hamburg's input?
I don't know. That would be speculation.
Okay. But the point is the agency had a solution here that would have allowed it to conduct inspections, was my understanding. But so the FDA failed to even acknowledge the existence of this guidance document until it produced it to this committee in March of 2013, well after the FDA promoted an entirely new regulatory paradigm. Here is where I want you to help clarify this for all of us. My question is, what does FDA now know about the compounding industry that it did not incorporate into this guidance document and is provided as a learning experience to make some changes? You may respond.
What we have seen as we have done inspections of this industry, we have focused on the highest risk areas, and we've seen violations of aseptic processing that basically mean that there's no assurance of sterility of the products coming out of these compounding pharmacies. And this means that this outbreak that we've seen will happen again. Since the outbreak, we've had an instance of fungal bodies being observed in an IV bag ready to be given to a cancer patient, all right, that came from a compounding pharmacy. We've also had other instances of patients having eye infections and other instances of non-sterility products. So we've had harm as well as the non-sterile practices that lead to the harm.
But with regard to the way that FDA approaches these things, and I understand you're looking for more authority to handle some things, but what we really need to know is within the realm of the authority you already had, and I'm not asking you to hang anybody out right now, that's not the purpose of this hearing, but are there internal lessons that the FDA has learned they could have handled some things differently, that could have possibly led to some different results, other than dealing with the lawyers' issues here?
Well, I think we should have been more aggressive. There was great concern, about the limitations of our authority and that we would lose and then have even less ability to influence this industry. But in retrospect, I think it would have been more important to simply go forward and see how it turned out in the courts, aggressively exert our current authority, which is primarily New Drug Authority.
Thank you. That's why I like hearing from a physician instead of a lawyer. I'll need to submit those emails for the record, if that's all right, Mr. Chairman.
With that objection, so ordered.
Subject to redactions by staff. Thank you. Thank you so much, Doctor.
Chair, thanks, gentlemen. Now recognize the gentlelady from California, Ms. Capps, 5 minutes for questions.
Mm-hmm.
We're going in order of appearance. Hit the mic button. Yep.
For holding this necessary hearing. This is an important issue and I believe needs to be revisited. Under current statute, a great deal of uncertainty and variation exists between regulations, and this uncertainty creates gaps that can lead to compromised patient safety, as we have seen most recently with the meningitis outbreak. We cannot wait for another public health crisis to act, and what we have right now isn't working. I believe you would agree. Families don't have the peace of mind they are receiving effective drugs that they can trust, and compounding pharmacies across the state are not on a level playing field. Many states are inadequately inspecting facilities. After a similar incident in my state of California almost a decade ago, regulations were enhanced, and sterile compounding pharmacies now require an inspection or accreditation through a national agency. But this isn't good enough, because many hospitals and clinics in California buy drugs from out of state, compounding pharmacies in other states, including the Massachusetts pharmacy. So hospitals and states don't exist in isolation. Hospitals have a great need to be able to buy large quantities of compounded drugs. Mr. Migliaccio suggests in his written testimony that there should be no special regulatory program for these large-scale drug compounders. Instead, he implies that they should be treated like conventional drug manufacturers and should have to go through the new drug application process to manufacture and distribute any drugs. My question now, Dr. Woodcock, could you explain to us why you believe requiring new drug applications for all drugs would not be warranted, and what the consequences would be, particularly for hospitals, if FDA were to take such an approach?
Well, that approach would be our current authorities. It's not that we don't have current authorities. Our current authorities require, submission of applications, payment of a user fee, thanks to the user fee bill you all passed for generics recently, and we've had the new drug one for a while, and review of all the information, a large package submitted to the agency, and then we inspect those facilities frequently, including a pre-approval inspection to make sure everything is okay before the product gets out on the market. So that's our current authorities. Now, many of these outsourcers, what they're actually doing is taking FDA-approved products and putting them into convenience forms or putting them into combining them, say, for hyperalimentation or something like that, and then shipping them around the country based on patient need. The industry has basically told us that, you know, they can't make all these different very patient-specific forms and convenience forms. And there aren't questions of efficacy that are related because these are already FDA-approved products. The key is, and this used to be done by the hospital pharmacy, by the clinic. They would do this. I did this when I was an intern, all right, when the interns were able, you know, had to be kind of worker bees. So we made up the chemotherapy. We put things into bags, and the nursing staff would do this as well, or the hospital pharmacy. Now, with the very large scale of medicine, they want to buy these, and many of the clinics are in office buildings. They don't have a pharmacy or clean room there, so they need to order these products, right?
I want to get to another question.
I'm sorry. It's so complicated. Well, let me finish then.
Okay.
So there isn't a good regulatory fit right now. It isn't where we're saying we have to have all these broad new authorities. No, there's no fit for this industry that's grown up. All right.
All right. I want to make sure that I'm able to enter a statement from the American Society of Health System Pharmacists, which addresses this issue as well. Their statement details the many ways in which hospitals have come to rely on compounded medications from outside compounding pharmacies, which you're alluding to. And I want to ask that this statement that I'm holding up be entered into the record. Dr. Woodcock, well, if there's time for you to address this, would a two-tiered regulation system that clarifies a uniform set of rules for compounding manufacturers while preserving the state's role in traditional pharmacy compounding be a practical thing? I'll just let you comment on that.
Yes, I mean, we have proposed something like that as something that would be practical, but it would require a new regulatory scheme for this new industry that has evolved, right, to make sure they're making the products safely. It's no good to have convenience products if they're contaminated or they're super potent or there are other things wrong with them. However, of course, that's up to Congress whether they want this industry to persist, because our current regulatory authorities require submission of applications.
I see. Okay. Thank you. I yield back.
And did you want to submit that for the record?
Yes, I would like.
Without objection, so ordered. The chair recognizes a gentlelady from North Carolina, Ms. Elmers. 5 minutes for questions.
Thank you, Mr. Chairman, and thank you, Dr. Woodcock, for being here today. I just want to clarify just a few terms because I think we're putting terms out, and I just want to make sure that I'm understanding. When we're talking about traditional compounders, who are we talking about?
We're talking about pharmacies, licensed pharmacies, who react to a prescription for a specific individual patient and make a specialized dosage.
And right now that is under the authority of the states, not under FDA.
Correct.
Okay. And when we're talking about the compounding manufacturers, how is that different? Is that different from the term the compounding manufacturers? I mean, the compounding manufacturers and the drug manufacturers. I mean,
compounding manufacturers is a new term that's contained in the Senate bill, okay?
Right.
To
reflect so this is Senate language.
Industry, this large-scale industry. They're not usually reacting to a prescription. They're making things that hospitals need and order frequently. So they make them at large scale, all right, like a drug manufacturer. But often they're not. A drug manufacturer starts from scratch. They start from what we call the active pharmaceutical ingredient, which they often somebody will buy from India or China, right?
Okay.
Bring it in, test it, and then make.
So sometimes it may be in a different form, but is it not the same product? Or and you're saying that because products might be coming from somewhere else that's the essential difference?
No, they're two different activities that are lumped under this compounding manufacturing. One is what we call the outsourcers, okay? They yet generally are outsourced from a hospital or clinic, something the clinic or hospital pharmacy used to do, all right? And that's putting things in syringes, little IV bags, diluting chemotherapy, getting everything all right, so they can just hang it on the patient rather than having to do that.
Rather than having to actually do it in-house. Now,
That's one. And then the other is people who are doing larger scale compounding.
and that would currently fall under the jurisdiction of the FDA.
That's what kind of is under
And that's
dispute.
what we don't, that's what we're trying to get to, is when do we make that distinction between compounding pharmacy and compounding manufacturer?
And also a manufacturer who's a pharmaceutical company who has to submit an application to FDA and be under that regime.
Okay. Now, currently, so basically the compounders have the same regulations and requirements as the drug manufacturers, yes or no?
No.
I mean, and I'm not just talking about numbers, but I'm just talking about, regulations. Again, is this state versus federal? Is that the main difference that we're talking about?
The states regulate pharmacies. They license pharmacies, and these activities right now occur all in licensed pharmacies.
Okay. What are the changes to compounding you propose making in order to prevent the meningitis outbreak last year to ensure compounding products are safe? What are you, if you can just quickly give us an idea of what you would like to see?
All right, we'll limit the traditional compounding to more or less reaction to a prescription, okay, and compounding something for a specific patient. That is traditional compounding, right? And don't allow compounding of really complicated dosage forms that even the traditional manufacturers have trouble making. Then we're saying establish a new group, the compounding manufacturers is what the Senate called them, okay? They don't get prescriptions, but they have to register and list with FDA, tell us who they are, what they're making, and where they're located, right? And then they have to submit adverse events to us. And they would be subject to proper GMP requirements to make sure they made safe products, okay? But they wouldn't have to submit applications to us, all right?
But you did mention application process a moment ago. Can you
well, sure. Well, some of the members are talking. We have current authorities. Yeah, we do have authorities. Our authorities are: you're a new drug manufacturer or generic drug manufacturer. You must submit application to us. You must pay a user fee, or you should not be producing drugs in the United States.
So once that application process is fulfilled, it's just so that you know that particular facility exists and what their plan of action is.
I'm sorry, it's really hard to do this. That's our current authorities. That's how we regulate generic drugs and new drugs in the United States, all right, through that process. That's not what compounding is.
Okay. Now, let me ask this question, because I know the number and how much we're making it seems to be the issue of where it falls, what jurisdiction. In your own words, where would you see that line of action? What do you see? How much product can a compounder make without being designated a manufacturer?
Well, see, that's what we've been struggling with since the 503 was passed. Okay, there's no line in there in the statute. And what is an inordinate quantity? All right, we don't know. Is it 10 units? Is it 1,000 units? Is it 17,000 units? So we have endeavored to use other criteria to say, okay, when you'd be subject to federal jurisdiction.
Well, my time has expired, but obviously that's the main question here. So thank you.
Well, we'd be happy to work with you.
Chair thanks the gentlelady. Now recognize the gentleman from New York, Mr. Engel, 5 minutes for questions.
Thank you, Mr. Chairman. Dr. Woodcock, thank you for the good work that you do. We appreciate it very much.
Thank you.
I want to first ask a New York question. New York, it's my understanding that New York has no licensing requirements specific to compounding pharmacies, and according to the National Conference of State Legislatures, there's no requirement that New York pharmacies comply with the U.S. Pharmacopoeia Chapter 795 or 797 compounding standards. And according to the Pharmacy Compounding Accreditation Board, which accreditation is entirely voluntary, they say there are only 10 pharmacies in all of New York accredited for pharmacy compounding. So that being said, I am pleased that no New York pharmacies were included as part of the FDA's most recent risk-based priority inspections of 31 sterile compounding pharmacies. So what I want to ask us, New York specific, is does the FDA know which pharmacies in New York are compounding medications?
We have no way of knowing in any state. Okay, we have been told by the industry that there are 23,000 pharmacies that may engage in some form of compounding across the country, but we don't know who they are, where they are, or what they're making because they don't have to tell us.
So so I assume then that the answer would be no to this. Does the FDA currently have the authority to collect and test samples or examine the records of a compounding pharmacy in New York? And can you elaborate on why this information is critical for public health and safety?
Well, we do believe we have the authority to go in and get samples and look at records, but it's been contested.
Okay. Thank you. I'm intrigued by the part of your written testimony which lays out a proposed risk-based framework for a new legislative approach to compounding to ensure patient safety and health. First, you propose dividing the world of compounding into non-traditional compounders, which would be subject to FDA's jurisdiction, and traditional compounders who would remain under state oversight. Is there a concern that non-traditional compounders may create a category of pseudo-drug manufacturers? And if so, how do you protect against that?
Well, there's a concern that traditional manufacturers could actually be drug manufacturers in disguise, and that non-traditional manufacturers could be. And for traditional, we really feel the prescription requirement and the statement of medical need for the patient is important. For non-traditional, we have proposed a series of things, including that they would register and list with us so we would know who they are, and also not make copies of commercially available drugs.
And you mentioned the need for a sort of do not compound list as part of this framework. Can you explain why this is necessary and why you cannot do this using your current authority?
Yes, well, we feel that products, say we've withdrawn from the market for reasons of safety, should not be allowed to be then compounded, and U.S. citizens would then be exposed to them again. And we're seeing this now, as you know, in dietary supplements. We have to go after them because they sneak in drugs that have been pulled off the market. All right. So that's one category. Another category might be very difficult to manufacture dosage forms, where the pharmaceutical industry that has a lot of science available to them and a lot of engineers and scientists still has trouble making them reliably. Some of the patches, some of the inhalers, and so forth.
Can you? You sort of touched on this, but can you elaborate further on what steps the FDA is taking now, utilizing the authority that you believe that the FDA has to conduct improved oversight over compounding pharmacies?
Well, it's more oversight on whether it's improved, because we are having to go to the ones we read about or we know about or we've had prior actions, and we're doing a risk-based approach and going to those pharmacies as well as going to pharmacies where we've had reports of problems recently, all right, and for cause type of inspections. And as I said, we're going in with the states, the state board of pharmacy, they're investigators. We often do an inspection together, and we're taking very aggressive action. But we do not, for example, have recall authority. We don't have the authority, we don't have recall authority for any drugs, right? And we do not have the authority to shut these pharmacies down. They are licensed by the state. But we've shared full information with the states, and they have shut 11 pharmacies down as a result of the findings in these inspections. So that is improved oversight, but we'll see about, if we go to court, like what kind of response we get from the courts as far as our authority.
Well, again, thank you for the good work that you do, and I especially appreciate your testimony here this morning. It's concise, it's to the point. When we ask a question, you respond very pointedly, and it's very much appreciated. Thank you.
Thank you.
Chair, thanks, gentlemen. Now recognize the gentleman from New Jersey, Mr. Lance, 5 minutes for questions.
Thank you, Mr. Chairman, and good morning to you, Doctor. You stated to Dr. Murphy that if you had it to do over, you might move more aggressively regarding the situation that unfortunately occurred. Is that accurate?
Well, I think we would have moved aggressively as we are now against all pharmacies. There was no way to predict at any time which of these pharmacies will cause this problem. And as I said, it will happen again, because the conditions that under which these sterile products are manufactured are not acceptable, and the products are contaminated. What I've learned from this is the resilience of the human body to microbial invasion, because we have cultured many samples from these pharmacies, and we've grown organisms, and we haven't had outbreaks, and that's because both the human body can repel them and because some of them aren't human pathogens.
Thank you. This is a very complicated subject, and certainly I think answers require more than yes or no.
I'm sorry. Okay.
And you don't have to be sorry at all. I think that this is extremely complicated. One of the difficulties as I read the background information is the split in the circuits. Are you advised by attorneys at the Department of Justice on these matters, or do you have attorneys at your own agency regarding the significant split between the Fifth and the Ninth Circuit and the Supreme Court decision?
Yeah, we have our staff attorneys that belong to the Office of General Counsel at HHS, and they're the FDA branch of that, and then they work with the Justice Department as well.
Perhaps you're not the appropriate person to ask, but it seems to me, speaking as an attorney, that there needs to be much greater clarification so that there can be one standard across the nation and not a split between the circuits with a Supreme Court decision that did not answer the question fully. Would that be your understanding of
That is my understanding. I'm not a lawyer, but I appreciate clarity when I try to perform regulations.
And I would hope moving forward in our responsibilities to protect the health of the nation, in conjunction with your responsibilities, that we could work together to clarify the situation. I have 2.5 minutes, and I defer to Dr. Burgess.
I thank the gentleman for that. Well, Dr. Woodcock, what is it about the Excerohilum fungus that rendered it such a bad actor? He said sometimes the human body actually can resist these things. Sometimes they don't even register. But
Okay.
Excerohilum was a bad one.
Okay, well, let me talk in general, so I'm not talking about NECC. But clearly it's the amount of bioburden of the contamination, and that's why shipping these, bioburden means how many organisms are in there, okay, for the non-clinicians in the room. And so shipping something around unrefrigerated, which is happening a lot, okay, if you happen to get something in there, it gets a long chance to grow, all right? If you put in a part of the body that is sort of protected from the immune system a little bit, or is particularly vulnerable, that if you inject with a steroid, we've had multiple outbreaks where there is injection with a steroid. And of course, steroids suppress the immune system, so then that weakens that part of the body, and even systemically weakens the body's ability to respond to an infectious attack because of the actual medicine that's been given. But we've had sepsis from IV products. 9 people died in 2011.
Sure. Let me just to stop you there, because we obviously could go on.
Yeah.
But that's significant, because you have a steroid which inhibits fighting infection. You have a space in the epidural space that is relatively protected from white blood cells and things that normally fight infection. It's preservative free because it's going to go into the epidural space. If you had preservatives, that would be bad for the nerves. So it is the
high risk
confluence of bad events. So this stuff is high risk. On the issue of manufacturing, I just have to tell you, looking at the notes compiled by the other subcommittee, Oversight and Investigations, going back to May 10th, 2011, when the Colorado Board of Pharmacy issued to NECC a cease and desist order, and the same day FDA's Denver office informed New England of the cease and desist order. New England compliance officer responsible for NECC spoke to an optometrist with the U.S. Department of Veterans Affairs, inquiring about whether or not they could use NECC to repackage Avastin. This communication is significant because, once again, it confirms that FDA understood that NECC was acting like a manufacturer, not a traditional compounding pharmacy. An email response, quote, "I did not think they could use firms if profiles were unacceptable. NECC Framingham is profiled as a manufacturer because we determined that they are a manufacturer and not a compounding pharmacy." An email from the compliance officer from the New England District to FDA, May 11, 2011.
Well, I'm not going to argue with you about this particular case because I can't talk about the case, but clearly that the decision about whether a firm is making making product legally under 503A would be for the courts ultimately. All right, that's just how it was set up.
But under the Food, Drug, and Cosmetic Act, if I may, you have the regulatory authority over manufacturers, and your own compliance officers identified NECC is a manufacturer, acts like a manufacturer, walks like a manufacturer. They are a manufacturer. Mr. Chairman, I'll yield back.
Chair thanks the gentleman. Now recognize the gentleman, Mr. Butterfield, for 5 minutes for questions.
Thank you, Mr. Chairman, and thank you, Dr. Woodcock, for your testimony today. I will be brief. The hour is certainly getting late. But in studying this issue, Mr. Chairman, it seems that the FDA lacks clear direction and clear authority over what can be done once a compounding pharmacy is found to have failed to meet the standards. And so, Dr. Woodcock, after the meningitis outbreak at the New England Compounding Center about a year ago, FDA increased its inspection of compounding pharmacies. I think that's true. The findings by federal investigators have been alarming, and hopefully there will be more aggressive investigations. I want to take you to the subject of sequestration. FDA is understaffed, underfunded, and stretched very thin. At least that's what we've been told. How are the cuts from sequestration hindering the FDA and your inspectors from conducting the thorough oversight that is critical to patient health?
Well, don't forget, we've the Energy and Commerce Committee overall have been very concerned that we haven't been to manufacturers overseas, traditional drug manufacturers, and that's been partly due to our resource limitations. Now, we do have the user fee, the Generic Drug User Fee Act, and that will allow us to increase our inspectors who go overseas. But my point is, even the traditional industry, we have difficulty covering that adequately. Now, there are over 20,000 compounding pharmacies, and we don't know who is who. And so the next...
Can some of your lack of resources be attributable to sequestration?
Oh, yes, absolutely. Well, sequestration took another bite out of what was already a stressed agency, particularly as far as inspectional coverage. And now, to give you perspective, the whole drug industry has about 5,600 establishments, all right? And so we try to inspect those on a regular basis. To say now that there are 20,000, 26,000, 28,000 compounding pharmacies, the question is, how would we get there? And then sequestration has reduced our funding, our user fee funding, as well as our base appropriation funding.
And is that really having a negative impact on your work?
Absolutely.
Now, does your agency fully understand that sequestration is not a one-year process? It is a 10-year process. So unless it's repealed or modified, it's going to continue for some years to come.
We have grave concerns about our continued ability to operate our programs under the various financial stresses that we have and these new activities that we need to take on.
Dr. Woodcock, what is an FDA Form 483?
That's a form with the investigator's observations that's left with the firm at the end of the inspection, all right?
Are these posted on the website?
Yes.
Okay.
They're public.
Okay. And from what we can gather, some 48 Form 483s that have been conducted are posted on the website.
Yes. We're posting them publicly to make sure that people understand what our findings are.
And what are some of the worst conditions that have been observed by some of your inspectors?
Well, primarily it relates to not having practices that would assure the product would be sterile. Don't forget, these are going to be injected into people's bodies, into their eyes, around their spinal cord, into their veins. And the practices would allow fungal spores, mold, contamination from the body of a person, so that would be bacteria, to actually get into the products and then multiply.
Finally, are there any tools, other than money, of course, that Congress can provide to the FDA so the American people can feel more assured that the compounded drug they're taking is prepared in a safe and secure way?
We need clear lines of authority. We need to know what the states regulate, what the feds regulate, and what our authorities are. If we regulate part of the industry, I would like to know who they are, where they're located, and what they're making, so that then we could prioritize where to go, because we're not going to get to thousands and thousands of sites in the next several months.
Thank you. You've been very kind. I yield back.
Chair, thanks, gentlemen. Now recognize the gentleman from Utah, Mr. Matheson, 5 minutes for question.
Thank you, Mr. Chairman. Dr. Woodcock, it's always good to have you before the committee. I've always appreciated my conversations with you. And I appreciate you trying to highlight an issue where I think it's all important we take a hard look at this and figure out if there's a better way to go forward. I think that's, if I want to oversimplify this hearing, that's kind of where we are. I fear my questions may be a bit repetitive for what you may have already covered. That's the reality of being one of the last people to ask questions. But I was interested, as I understand it, when the FDA discussed some enforcement actions back in 2006, can you tell me at that point can you elaborate what actions were discussed by the agency 7 years ago? Are you familiar with that discussion that took place, or that's before your time? Maybe you can't answer.
No, I wasn't. I wasn't the head of Center for Drugs at that time either.
Sure. You present several policy options in your testimony, and it's going to provide FDA some different authorities for certain compounders. Can you describe how those options, how they might have played out, allowed the 2012 outbreak to play out differently than it did if you had those options at the time?
If we have clear federal authority and clear idea of what is traditional compounding and what is not traditional compounding. Because don't forget, this industry has maintained they're working within the scope of state pharmacy practice. That's what they have maintained all along, all right? And so we need clear understanding of what is the scope of traditional pharmacy compounding practice, which FDA has always supported as appropriate in providing individualized therapy for people, and what is beyond that and requires federal oversight. And to make sure that's delineated, and I think you'll hear from the other witnesses, that's delineated from people masquerading as one of these buckets who are actually drug manufacturers. So we need clarity in whatever, and if Congress decides not to allow compounding manufacturing at all right, then we've heard from the hospitals and the clinics that would be a tremendous burden on them because they'd have to take back all this that they had outsourced.
Okay, Mr. Chairman, that's all I'm going to ask now. I'll yield back.
Chair, thanks, gentlemen. Recognize the ranking member of the full committee, Mr. Waxman. 5 minutes for questions.
Thank you very much, Mr. Chairman. Dr. Woodcock, your testimony states that the current legal framework does not provide FDA with the tools it needs to appropriately regulate the compounding industry in its current state. You explained that you are referring both to Section 503A and other parts of the Federal Food, Drug, and Cosmetic Act. I'd like to start with Section 503A. Obviously, as you explained to Mr. Pallone, there are major questions about whether it would even remain in effect if challenged in most of the country apart from the Fifth Circuit. With regard to the circuit split, Representatives Barton and Griffith have asked why you could not fix this with guidance. Can you explain what a guidance could or could not do to address the circuit split?
Certainly. A guidance says on every page that it is not binding either on FDA or the industry. That's what it says on every page. It's more or less an explanation of our thinking. It doesn't add new requirements or cannot solve differences in court opinions.
But putting that aside, you say that Section 503A actually contains provisions that have impeded FDA's ability to effectively regulate pharmacy compounding. Can you elaborate on what those provisions are and how they have impacted FDA's oversight of compounding pharmacies?
Yes, well, I think there are provisions in there that are vague, and so we need clarity about what is the line. So, for example, it says you shouldn't compound without a prescription in inordinate amounts. Well, what is inordinate? That's in the eye of the beholder. The industry has maintained that all their activities, regardless of their scale, are within the scope of traditional pharmacy compounding.
The Oversight and Investigations Subcommittee of Energy and Commerce conducted a detailed investigation involving thousands of pages of FDA documents. One thing we found in that investigation is that for years, going back to the Bush administration, key FDA decision makers have, in numerous internal meetings and memoranda, indicated that Section 503A is inadequate and that new legislation is necessary. Are you familiar with any of these documents or any of these internal discussions?
Well, I was present in the early 2000s when the court cases came down, all right. We had been preparing to try and implement 503A and making the preparations for that when the circuit court and then the Supreme Court ruled. So I'm familiar with that set of discussions.
Well, is it fair to say that the agency leaders going back to the Bush administration understood that they needed new legislation because of fundamental weaknesses in Section 503A?
Yes, it was very difficult to implement in any reasonable manner.
Mr. Chairman, the notion that FDA is asking for legislation simply to cover for past mistakes or in some sort of power grab is not correct. For years, though, through two different administrations, agency leaders have known that there were problems with the underlying law. Let's turn to the other provisions of the Act apart from Section 503A. Dr. Woodcock, your testimony indicated that you're encountering difficulty when you attempt to inspect compounding pharmacies now using your current authorities. You mentioned that you actually had to seek a warrant in 2 cases after the pharmacies delayed or refused your access to records. Can you describe in more detail exactly what has happened during those inspections and describe which current statutory provisions are contributing to the difficulties you have faced when attempting to conduct inspections?
Well, I probably can't speak to statutory provisions, I'm sorry, but what's happened is we've gone in there, and as I said, the industry has long maintained that we do not have authority over these licensed pharmacies that are in states, right? And so we go in and we ask to either inspect or to inspect records, and they say we did, under some of the court cases that have occurred, we don't have to turn over records to you.
So some might argue that there's no problem here since you were eventually able to conduct the inspections and obtain the records you were seeking. But can you
certainly
speak to that assertion?
The real problem is what is clarity? What is a compounding pharmacy? What is a traditional compounding pharmacy? What about the status of these large scale? And how do you define a large scale operation? How do you know, you might say, well, I know it when I see it. Okay, but how do you, what is
Well, I was amazed to hear during your responses to earlier questions that in order for FDA to begin conducting the more recent inspections, you had to actually look in the newspapers and at the television ads and websites to even know where the compounding pharmacies were. Obviously, we don't ask you to have to search the internet or watch TV to figure out where drug manufacturers are. What is the difference here, and do you need new authority to remedy the situation? And before you answer that, not only are we uncertain as to the continued validity of FDA's authorizing statute with respect to compounding pharmacies, but that statute itself is plagued by problems. So I think we need to clarify the situation, but why should you have to go on TV and the internet to be able to do inspections?
Because they don't have to tell us who they are, where they're operating, and what they're making. They don't have to submit anything to us. They're operating under state law. And they don't have to send us adverse events if they occur, even deaths. We would read about them in the paper, hear from the CDC or State Health Department. That's how we hear, or a consumer or doctor will call us. So that's how we learn about this, and we don't know of all this universe of 28,000 firms. We don't know what they're doing. And so you might say, well, you should know about this, but when it happens, most of our actions have been reactive to things that we've heard about.
Thank you very much. Thank you for your indulgence.
Chair, thanks the gentleman. We're voting now on the floor, so we will again recess until the floor votes are concluded, and then we'll come back and reconvene with the second panel. I think all of the members have asked their questions. There may be some follow-up questions.
Certainly.
We'll ask you to please respond when we send you those. And so at this point, we'll recess until conclusion of the floor votes. The time of our recess having expired, we'll reconvene our hearing. At this time, I would like to request unanimous consent to enter a statement from the National Association of Chain Drugstores into the record. Without objection, so ordered. At this point, I'll introduce our second panel. Today on our second panel, we have Dr. Scott Gottlieb, Resident Fellow, American Enterprise Institute, Mr. Joseph Harmison, owner, Harmison Pharmacies, on behalf of the National Community Pharmacists Association, Ms. Elizabeth Scott Russell, Government Affairs Manager of the National Association of Boards of Pharmacy, Ms. Gabrielle Cosell, Manager, Drug Safety Project, Pew Health Group at the Pew Charitable Trust, and Mr. Jerry Migliaccio, Quality Systems Consultants Iglesias Consulting. Thank you all for coming. You will each have 5 minutes to summarize your testimony. Your entire written statements will be entered into the record. So, Dr. Gottlieb, we'll begin with you. You're recognized for 5 minutes for an opening statement.
Thanks a lot, Mr. Chairman Pitts, Mr. Ranking Member Pallone, and members of the committee. Thanks for the opportunity to testify today. I have a longer statement for the record. I'd like to summarize a few key points for you this morning. The tragic deaths of 55 Americans and the sickening of more than 740 resulting from contaminated steroid injections that were shipped by a disreputable firm have rightly focused public attention on a largely unfamiliar but prominent part of the drug supply chain, the practice of pharmacy compounding. Before this Congress are proposals to tighten federal regulatory oversight of these compounding pharmacies and the practice of pharmacy more generally. Observers are calling on Congress to give the FDA more oversight of these firms. New laws merit consideration. We should articulate clear and bright lines between the legitimate practice of pharmacy compounding and those firms operating illegally as large-scale manufacturers under the guise of a pharmacy license. Some key considerations should, in my opinion, guide this work. First, there exists a practice of pharmacy. It was never intended that all compounding would create a new drug and be subject to FDA regulation, but for the enforcement discretion or for the willingness of Congress to provide explicit exemption to certain pharmacists and certain activities that pharmacists undertake. Second, FDA has authority to target compounders that cross the line between the practice of pharmacy and engage in drug manufacturing under the guise of a pharmacy license. What FDA largely lacks is ease of administering this authority. FDA is generally not able to force firms to submit advance information to the agency before the firm is suspected of any wrongdoing, and so that the agency is more efficiently able to identify firms engaged in wrongdoing and target its oversight. Third, FDA generally lacks tools and resources to regulate a new class of firms that the agency has dubbed non-traditional compounders. I would argue that the firms in question here are not compounders, and calling them such confuses different issues. Rather, they are engaging in the bulk, large-scale repacking and manufacturing of sterile preparations of FDA-approved drugs, typically in advance of and often not in response to prescriptions for individual patients. To the degree that these large-scale operations prepare sterile volumes of drugs in a bulk form and ship these units widely, they present some novel risks, and they have the potential for what I would call distributed risks. The public health could benefit from applying additional oversight to these firms, especially requirements that they adhere to good manufacturing practices. Fourth, as we address issues of supply, we must also address the policy decisions that have increased demand for products from some disreputable firms, some large-scale compounders who are breaking existing law and violating existing regulations. For example, a recent crackdown in the manufacturing of generic drugs has shifted a lot of the demand for generic preparations to compounders. Likewise, decisions by FDA to suspend enforcement against compounders in certain select situations where the agency and policymakers had concerns about the high cost of FDA-approved drugs relative to the low cost of compounded versions has also given greater license to certain compounders to bend, if not break, existing law. Consistent enforcement is going to be especially important if we create a new class of compounders that FDA has dubbed the non-traditional compounding. If FDA doesn't exercise this enforcement evenly and consistently, which means not allowing firms to compound identical versions of FDA-approved products, then the agency will give more incentive for drug makers to remask themselves as non-traditional compounders to skirt FDA's new drug requirements. Finally, the market for compounding drugs is evolving very quickly. It's consolidating as other entities like distributors could well start buying out the large compounders. As this process unfolds, it will leave behind a much different compounding industry. This should serve as a cautionary tale to all of us. We should be mindful that the rules that we might write today would no longer be applicable to the market that we see tomorrow. Thank you for the opportunity to testify this morning. I look forward to your questions.
Thank you, Dr. Gottlieb. Mr. Harmison, you're recognized for 5 minutes for opening statement.
Thank you, Mr. Chairman. I wish I could speak as quickly as
Poke the button on that. If you'll push the button on that. Speak into the mic, please. Thank you.
Okay. No strength of finger. Excuse me. Chairman Pitts, Ranking Member Pallone, Vice Chairman Burgess, thank you for the opportunity to be here today. As stated, I am Joe Harmison. I'm a practicing pharmacist, pharmacy owner, and past president of the Texas Pharmacists Association and the National Community Pharmacists Association. NCPA appreciates the opportunity to share the community pharmacist perspective regarding issues relating to drug compounding. NCPA represents the views of community pharmacists, including 23,000 independently owned community pharmacies. According to an NCPA member survey, 86% of our members do some kind of compounding. This can range from flavoring
pediatric liquids, to changing dosage forms for patients that can't take oral solids, to topicals, to injections. In my practice, we mainly emphasize pain medications, and we are U.S. Pharmacopoeia 797 standard compliant. Our hearts go out to the families who have suffered from the tragic events surrounding the New England Compounding Center, and MCPA is committed to working with Congress on the issues of practice that exceed state-regulated compounding. NCPA commends the committee for taking a closer look at those actions and inactions that led to the tragic NECC event. We believe the committee is taking the proper steps to address this tragedy by focusing its investigations on what steps should have been taken and oversight that ensures that the proper regulatory bodies are exercising their full authority. Compounding is the backbone of pharmacy. It goes back to the time of the alchemist. For centuries, pharmacy only did compounding until in World War II, then commercially prepared medicines became more prevalent, which is still the thing today. But it did start dawning on people a couple of decades ago that there are people that need something that just isn't commercially available. So compounding came back into being an important part of the pharmacy practice. Another thing, compounding, excuse me, serves to bridge a gap which we're experiencing more and more when commercial products are not available. Patients must be assured that they are not forced to go without medicines or their treatment because medications are unavailable and compounding for that medication is prohibited or tied up in bureaucracy. It is important to reiterate that pharmacist compounding is an integral part of pharmacy profession and meets patients' needs in hospitals, long-term care, home infusion, hospice, every community setting I can think of. NCPA has always and will continue to advocate that pharmacy compounding is best regulated by the state boards of pharmacy, while manufacturing oversight is the purview of the FDA. Pharmacy compounding medications is an important part of the medical care and allows the dispensing custom-made medications and should continue to be related by state boards of pharmacy, as all other medical profession licenses are. State boards of pharmacies currently oversee all aspects of pharmacy, and in most cases, their records are public, so it's not hard to obtain who's doing what. If the FDA has concerns about appropriate licensed pharmacy, then the FDA currently has the authority to ask the State Board of Pharmacy to work with them to address the issues. If this is found to have an entity that is acting under the guise of a pharmacy and is exceeding its state-regulated authority, then the state boards of pharmacy should suspend the license of that pharmacy until it complies with the state regulations and or meets the FDA regulations to be a manufacturer. All parties involved must make certain that the state boards of pharmacy are adequately staffed, trained, and funded to effectively regulate compounding. NCPA encourages the state boards of pharmacy to require uniform compliance with USP 797 standards in order to provide more uniform product standards. As such, every state will be assured that resident and non-resident pharmacies alike are all in compliance with USP standards. In most cases, compound medication must originate from a prescription for a specific patient. There are times that we may do things in advance, but we have to be able to prove that we use historically a certain amount in a very short period of time. I'm out of time. In accordance, we should not make rules that compounding should not be defined by nuance such as types of product, whether it's sterile or non-sterile, as risk of and complexity of compounding is not solely dependent on the product type. Neither is quantity of the product made in a pharmacy bearing, because we can make many different things and they are all safe. And interstate commerce should not be the same, because was stated earlier, We are a border state to 5 different states, and being rural, there are places that just have to go across state lines. But if it is at the issuance of a prescription for a specific patient, for a specific malady, this should be allowed and under the purview of the states. Thank you for the opportunity to be here. NCPA pledges to work with Congress to put this to rest.
Chair, thanks, gentlemen. Ms. Russell, you're recognized for 5 minutes for an opening statement.
Thank you. Good afternoon, Chairman Pitts, Ranking Member Pallone, and members of the subcommittee. The National Association of Boards of Pharmacy appreciates the opportunity to appear before you today and provide information related to pharmacy compounding. I'm Elizabeth Scott Russell, Government Affairs Manager for the association. As part of a comprehensive action plan that assists states following the meningitis outbreak, NABP partnered with the Iowa Board of Pharmacy to begin conducting inspections of all of its approximately 600 non-resident pharmacies, focusing first on those delivering compounded drugs into Iowa. Our inspections confirmed that the activities that occur with NECC were also occurring at other facilities in other states. To date, NABP has inspected approximately 165 pharmacies and is in discussions about similar inspection programs with other states. We are building a system of proactive information exchange for all pharmacies that will include verifications of licensure, disciplinary checks, and assurances of a timely and robust inspection that meets uniform standards at no cost to boards to assist them in making licensure and registration determinations for non-resident pharmacies. NABP does believe that federal legislation is needed to provide the needed distinction between compounding and manufacturing to address critical concerns and provide a safe and equitable environment for both to occur in the best interest of the patient. NABP supports the major concepts of the legislation proposed by the Senate Help Committee and welcomes the proposed clarifications to the regulatory uncertainties that currently exist, uncertainties that were a primary factor leading to the recent meningitis tragedy. In particular, NABP affirms that the regulation of the practice of pharmacy remains the responsibility of the state boards of pharmacy and agrees with the language in the proposed Senate legislation that defines traditional pharmacy compounding as part of the practice of pharmacy to be regulated by state boards of pharmacy. NABP also supports the establishment in legislation of a new category for the preparation of non-patient specific sterile products that would be registered and regulated by FDA, and a clear distinction between this new category and traditional pharmacy compounding. Although we understand that some terminology must be employed to describe this new category, we would prefer that the term compounding not be included in the name because of potential confusion with traditional pharmacy compounding. NABP supports federal legislation prohibiting entities that fall into this new category also being licensed as a pharmacy by the state, as this separation is essential to addressing the ambiguous authority that currently exists between the states and FDA, that is, who is responsible. Our experience affirms the importance of a clear separation between manufacturing and compounding and clarifying what activities fall under federal jurisdiction and what fall under state jurisdiction. Not having a clear separation could also provide a veil for unscrupulous entities to hide their activities. NABP does not believe that the interstate distribution of non-patient specific sterile products should be a required criteria for meeting this definition, this new category, as is in the Senate proposal. We understand the need to establish a delineation point, but such differentiation between intrastate and interstate distribution could create patient safety concerns by allowing large-scale intrastate entities to avoid federal regulation. NABP could still support proposed legislation that exempts intrastate distributions from the definition for this new category, provided the situation is monitored for any additional future action that may be necessary. In conclusion, NABP believes there is a need for federal legislation that addresses the safe preparation of compounded medications for patients, that distinguishes between compounding and manufacturing, defines a new category of manufacturers under FDA regulation, balances effective regulation with reality, and carefully constructs the scope and activities of this new category to meet patient needs while maintaining necessary protections We appreciate this opportunity for input and are available to discuss our comments and any legislative solution in greater detail. Thank you.
Chair, thanks, gentlelady. Ms. Cosell, you're recognized for 5 minutes for an opening statement.
Thank you. Chairman Pitts, Ranking Member Pallone, Vice Chairman Burgess, and members of the subcommittee. Thank you for the opportunity to testify on the need for federal legislation to improve the safety of compounded medicines. My name is Gabrielle Cosell. I work on pharmaceutical quality and safety at the Pew Charitable Trusts, which is an independent research and public policy organization. Pharmacists have always compounded medicines, but many of the activities we refer to as compounding today are far removed from traditional pharmacy practice. In recent months, this committee has stressed the responsibility of FDA to ensure the safety of activities that depart from traditional compounding and are more akin to manufacturing. And today I'll focus on a regulatory framework that clarifies the agency's role, ensures that limited resources are used wisely, and sets clear expectations for the industry. First, though, it's important to look over the risks. The fungal meningitis epidemic illustrates how patients can be harmed by substandard compounded drugs, but it's far from an isolated incident. My written testimony describes 19 additional pharmacy compounding errors from the past decade that have caused serious injuries and deaths in at least 29 different states. The list includes meningitis, bloodstream infections, and at least 38 patients who suffered partial or complete vision loss. Recent history raises further concern. 2 months ago, a New Jersey compounder recalled all of its products because of mold contamination. When a drug is produced in mass quantities, the potential harms from a quality failure also multiply. There are companies today that compound thousands of packages of vials of medicines and ship them to buyers all over the country. These activities have outgrown the state regulatory structures established to oversee them. Federal law already regulates some aspects of compounding, and today we urge you to make changes to ensure clarity and effective oversight. First, large-scale compounding should be subject to higher quality standards, specifically applicable good manufacturing practices. Second, the FDA is the appropriate agency to oversee GMPs, and states should not exercise redundant oversight. And finally, patients must be protected by ensuring that compounders do not undermine gold standard FDA-approved drugs. Compounding quality standards are currently set by the states, and they're variable. Pew recently joined with the American Hospital Association and the American Society for Health System Pharmacists to host a summit on sterile compounding, and experts at that meeting emphasized that pharmacy compounding standards were never intended and are not suitable for large-scale production. Compounding high volumes or repeat batches of medicines involves standardized processes and should be subject to applicable GMPs. The FDA is best placed to enforce these standards, but resources should be focused on activities that pose the highest public health risk. Facilities that produce large volumes of sterile products that may reach many patients, or that carry out particularly high-risk compounding, such as creating sterile products from a non-sterile bulk ingredient, should be required to register with the FDA. FDA should issue regulation clarifying the criteria for registration. As with pharmaceutical manufacturing, FDA should inspect compounding facilities on an ongoing basis with a frequency based on risk. And facilities should pay fees to ensure FDA is adequately resourced to provide this oversight. Under this framework, states may continue to require FDA-registered compounding facilities to hold pharmacy licenses, but state enforcement of quality standards should be preempted for these facilities. To exercise effective oversight, the FDA must have access to the records of facilities it regulates or that it believes fall under its jurisdiction. This requires a fix to current law. Even today, compounders continue to challenge FDA's access to records. Key safety requirements should also be set at the federal level, such as a do not compound list, and this should apply to all compounding facilities. It's important to state that large-scale compounding cannot be addressed simply by requiring these facilities to submit new drug applications. Some large compounders fill a niche in our health system, such as for hospitals that don't have sufficient capacity to mix drugs in-house. However, any new regulatory scheme must not undermine the approvals process and encourage compounding at the expense of traditional manufacturing. While the goal is to ensure the quality of compounded medicines, patients, doctors, and pharmacists should prefer FDA-approved products whenever possible. Only the latter go through pre-market review to establish safety, efficacy, and bioequivalence, along with pre-approval of manufacturing methods and facilities. Legislation should be clear that a compounder may not make a copy or a variation of a marketed drug, except when that drug is in shortage, or to address a specific medical need of a specific patient. In conclusion, I thank you for your leadership, and I urge you to create a clear, workable framework to protect patients. I welcome your questions.
Chair, thanks, gentlelady. Mr. Migliaccio, you're recognized 5 minutes for opening statement.
Thank you, Chairman Pitts and Ranking Member Pallone, for inviting me to speak today. My name is Jerry Migliaccio. I am a consultant in the area of pharmaceutical quality systems. In 2012, I retired from Pfizer Incorporated after a 33-year career in pharmaceutical manufacturing and quality operations. For 11 of those years, I served as the head of the Global Quality Organization at Pfizer. So this experience has provided me with quite an intimate knowledge of the quality requirements and regulatory framework applicable to manufacturing medicines for the United States public. Patient safety is the highest priority for pharmaceutical manufacturers. Companies comply with the gold standard of quality manufacturing as defined by FDA's current good manufacturing practice regulations and the associated guidance documents. These regulations apply to all prescription drugs approved for sale in the United States, wherever they are made, and extend to all components of a finished drug product, including the active pharmaceutical ingredients. FDA's regulations are based on the fundamental principle that you cannot inspect or test quality into a finished product. Quality must be designed into the manufacturing process and designed into the product. The regulations also drive manufacturers to establish a quality systems approach to assure consistent quality. In pharmaceutical manufacturing, quality systems and GMP requirements begin at the investigational stage. FDA requires that a new drug application describe the quality safeguards for the proposed manufacture of a new medicine in the chemistry, manufacturing, and control section of the application. Part of the evidence required by FDA to demonstrate safety and efficacy is the requirement that a manufacturer provide, and I quote, a full description of the methods used in and the facilities and controls used for the manufacture, processing, and packing of a new drug. The manufacture of medicines, whether by NDA holders or large-scale compounders, involves similar activities and similar potential for risk. Large-scale compounding can involve mixing of active and inactive ingredients as well as other manufacturing steps. Therefore, in order to assure the safety of the American public, the manufacture of medicines, whether by manufacturers or pharmacies, should be regulated in a consistent risk-based manner. Large-scale commercial manufacturing of prescription medicines, whether the producer is designated as a pharmacy or as a manufacturer, should be governed by the same high standards currently in effect for pharmaceutical manufacturing and subject to the same inspection and enforcement actions by FDA. Moreover, large-scale compounders should be required to prove that they can manufacture medicines consistently and safely by submitting an application to FDA containing a chemistry, manufacturing, and control section and submitting to both pre-approval and routine GMP inspections. Let me give you a personal perspective on the importance of GMP regulations. During my career, I considered the regulatory framework in the United States as the blueprint for assuring safety and efficacy. Whether you're a small startup company or a large multinational manufacturer, the regulations and guidance documents provided the template for success. From designing quality into a manufacturing process, to the selection of material suppliers, the construction of facilities, the selection of equipment, the training of employees, all the way to the final approval to distribute the product. The regulations and guidance documents provide for a consistent, risk-based approach to assure quality. The regulations have also evolved to encourage innovation and continuous improvement and to help support the justification of new technology to further enhance quality assurance. Therefore, it's just very logical to me that any large-scale manufacturer of medicines, including compounders, should comply with these same regulations. A manufacturer in full compliance will have a high degree of assurance that the medicines they produce will be of consistently high quality. A large-scale company making thousands of doses of medicine with the name pharmacy on the door and another with the name pharmaceutical company on the door should be regulated in a similar manner when they perform similar manufacturing steps and present similar risks to patients. Thank you for your attention.
Chair, thanks, gentlemen. I'll begin the questioning, and I recognize myself 5 minutes for that purpose. Dr. Gottlieb, the FDA has proposed creating a new category of, quote, non-traditional compounders, end quote. Do you believe this has the potential to add confusion rather than clarity to regulated industry?
Well, I do believe that there's this category of companies, large companies that have grown up that basically do the outsourced work of the hospitals, and it's not really traditional compounding in the sense that we understand that word. What they're really doing is sterile preparations of drugs, breaking down FDA-approved products into different formulations that make it easier to administer to patients. And it's a completely different thing than what traditional compounding is. I do think it creates the potential that traditional manufacturers might have a temptation to recast themselves into this new category if we don't have very equal enforcement and very aggressive enforcement of the existing law, because there will be an incentive to go into this pathway because it will be sort of a regulatory light pathway. The reason why Teva Pharmaceuticals doesn't manufacture all the formulations of propofol that doctors might want is because if they went about doing that, they would have to file an ANDA for each one and pay a user fee for each one. So if we create this category, it could be an incentive for traditional manufacturers to try to move back into this new category, and that wouldn't serve the public interest.
To follow up, impact on intellectual property rights. How would this new category potentially impact intellectual property rights?
Well, again, I think it could create an avenue for people to try to game around the new drug regulations to create products that would fit into this category. And it's not an argument for not trying to think about how we could apply GMP regulations to this new category of manufacturers, but it is an argument for trying to make sure that we enforce existing law against compounders who, for example, compound versions of FDA-approved products. In recent years, the FDA has backed off enforcement that was put into place to crack down on people who are engaging in the compounding of drugs that exist in FDA-approved formulations. And so that creates an incentive to try to obviate existing intellectual property.
Mr. Migliaccio, Director Woodcock mentioned on the previous panel that the agency could not require compounders to register with the FDA. However, the FDA has the full authority to require manufacturers operating under the guise of compounders to register with the FDA, like NECC. Isn't that correct?
Yes. Every manufacturing establishment within a pharmaceutical company has to have an establishment registration with the FDA.
Hasn't the FDA recently used its manufacturing inspection authority to inspect manufacturers acting under the guise of compounding recently?
I believe they have used their inspection authority to attempt to inspect compounding manufacturers, and I understand that they've been turned away in certain cases.
Please explain the similar scope of risk between NDA holders manufacturing drugs and large-scale compounders.
Well, pharmaceutical manufacturers make pharmaceutical products at very different scales. I mean, we make small volume, we make large volume. Compounders are doing the same thing. We're following similar manufacturing steps. We are taking active ingredients and inactive ingredients, combining them, trying to yield a product that has the potency and purity required by the patient. Compounding the problem with sterile products is the risk around sterility. Sterility is not something that you can test into a product. Yes, you do a sterility test, but it's not a reliable measure of sterility. You have to have a very robust system to assure sterility. And the GMPs require that we actually prove that to the FDA before we can market the product. We have to prove that we can assure sterility to a very high degree before we can put a product on the market. That is not the case. The risks are the same for compounding pharmacies, but they don't have to provide that same evidence.
Could legislation that applies different standards adversely affect the quality of drugs made available to patients?
Oh, I believe that that compounding pharmacies making product at large volume are manufacturers and should be regulated according to the manufacturing regulations, the GMPs, which have proven to be very successful in protecting the American public.
Let me squeeze one more question here, Mr. Harmison. What safety precautions are you required to comply with?
I comply with USP 797 and the state laws, rules, and regulations of the state of Texas.
And can you briefly describe the importance of traditional compounding that occurs in independent pharmacies across the country?
That is Mr. Chairman, that's a very broad subject. If we're talking about somebody making a cream, there's one thing. If I'm making a sterile injection, that's quite another thing. If I'm making a capsule for somebody, we still strive, basically, we're not going to make anything we wouldn't give to our children or grandchildren.
Thank you. My time's expired. I recognize the ranking member, 5 minutes for questions.
I wanted to start with Ms. Russell. In your testimony, you cite the need for FDA to be given new and better authority over drug compounding. Obviously, your organization is made up of state agencies that regulate the practice of pharmacies, so you're in a unique position to have insight into whether FDA needed new authority in this area. So, Ms. Russell, your testimony describes the fact that there were regulatory uncertainties that were a major factor leading to the NECC meningitis tragedy. Can you elaborate on what those, I always hate to say elaborate, but can you tell us what those uncertainties were and how they contributed to the meningitis outbreak?
Sure. I think that there are a number of entities in the United States, across the United States, that would tell boards of pharmacy that they were distributing non-patient specific sterile products as an FDA manufacturer. And they may have actually gone on FDA's website and registered as a manufacturer, and state boards of pharmacy didn't think they had jurisdiction over those particular activities. FDA didn't necessarily recognize them as an approved manufacturer because they hadn't filed an NDA. So there were uncertainties and ambiguities in who had responsibility over these particular firms.
So you also indicate that NABP is supportive of the Senate legislation clarifying the distinction between compounding manufacturers and traditional compounders. And you further indicate that your recent inspections of compounding pharmacies has underscored the importance of getting this clarity through federal legislation. So can you explain more about what you've done in your inspections undertaking? I'm curious about why, if NABP and the states have been able to conduct such widespread inspections recently, that isn't enough. In other words, what would be achieved by FDA through new federal legislation that can't be accomplished by the state boards of pharmacy?
Maybe I wasn't clear. We do think traditional pharmacy compounding should remain the purview of state boards of pharmacy, but we do think that there are these entities that are engaged in large-scale activities that more resemble manufacturing, and that FDA should have jurisdiction to inspect and investigate those. Our initial inspections that we've been involved in for the state of Iowa, part of it has been trying to determine which of these large-scale entities are engaged in these manufacturing, more resembling manufacturing type processes. And those are not condoned by the Iowa Board of Pharmacy nor most other states. And we don't think that state boards of pharmacy have the resources to be able to adequately inspect basically manufacturing operators that are operating under the guise of legitimate pharmacy practice.
And then thank you. Let me ask Ms. Cassill, I'd like to ask you a question that we heard a little about during the first panel. That has to do with hospital use of compounding medications. As we heard, hospitals have increasingly come to rely on compounded medicines that they obtain from large-scale pharmacies, and Dr. Woodcock talked some about how FDA's authorities to oversee these large-scale facilities are not appropriately tailored to the task. So I wanted to ask you, do you agree that hospitals do have a legitimate need for drugs from these large-scale pharmacies? Can you explain more about why they have come to rely on them, and what are your views on whether the FDA has the right authorities to handle regulation of that type of entity?
Yes, and I think the question is very astute because it hits on just what's at hand today. There's a question about bad actors and if they cross a certain line, whether they should be shut down, yes. But there's also a question of entities that do fill a niche in our healthcare system, such as the outsources you referenced, sir. And it's become clear over the years that hospitals have increasingly looked to outsourced operations to provide them sterile mixed products, mixed variations of finished FDA drugs. And the simple answer can't just be calling these entities manufacturers and requiring them to submit a new drug approval. We need to make absolutely clear that when you're compounding on a large scale and filling this niche for the health system, you should be held to high quality standards, GMPs, as my colleague Mr. Migliaccio testified on as well.
Mr. Harmison, I got a little time. Your testimony can be summarized as follows. States always have and always should regulate compounders with no role for the FDA. But we know that numerous failure by Massachusetts regulators led to the NECC tragedy. In light of this tragedy, is it still your view, and I don't mean you tell me if I'm wrong, is it still your view that states are capable of regulating large-scale compounders?
Yes, Mr. Pallone. I think if they have the willpower to do it, they have the ability.
So you agree, you don't think there is a role for FDA in the regulation of large-scale compounders like NECC?
I think the rule of the FDA is oversight. If they think that there is a problem, they should go talk to the state boards of pharmacy, say, come go with me, let's inspect this. If it's in violation of the state law, then the state should take action on them. If they say, we don't have this, somebody decide if they're a manufacturer. If they're a manufacturer, certainly they are under the purview of the FDA.
I don't know. It just seems to me that what you're proposing sounds nice in theory, but I think much of the testimony seems to indicate it doesn't work out practically. But whatever. I don't want to put words in your mouth. Thanks a lot.
Chair, thanks, gentlemen. Now recognize the Vice Chair of the committee, Dr. Burgess, 5 minutes for questions.
Well, Mr. Harmison, let's just continue on that line for a moment, because when another subcommittee of the Energy and Commerce Committee, the Oversight and Investigation Subcommittee, first started this investigation, we were joined by the brand new head of the Massachusetts Board of Pharmacy. And the reason she was the brand new head was because the old head had been recently dismissed because of the problems that occurred. We've heard from the FDA this morning that no, we're not going to replace anyone in our organization. It looks to me like the Massachusetts Board of Pharmacy acted, although there may have been problems leading up to the crisis, their response to the crisis and after seems much more reasonable than what I've seen out of the federal regulatory agency. Is that a fair assessment that I'm making?
As an employer, if I were in that position, somebody wouldn't be in my employ anymore.
Well, that's, this was just so baffling about all of this. I mean, again, the poor individual who was the brand new head of the Massachusetts Board of Pharmacy had to come in here and answer some pretty tough questions, and some for which she had no answer. And so we said, those people are no longer working for us, and you have to wonder whether or not there are civil or even criminal activities that are going to follow them for a while. I wouldn't be surprised to learn that. But again, you have a large federal regulatory agency, and they're immobile. And not only are they immobile after they find out that there's a problem, but the months and years leading up to this, we're going to have guidance, and it's bound up in some stuff. And I read you the email chain from 18 months before this crisis hit. They recognized that it was manufacturing, that they were required to list these compounds. They were required to submit to GMP. The people in the FDA understood that, and for whatever reason, it didn't translate to the street level to get it done. In fact, I don't think the people that were working the agency, again, I guess the mental image, they must be tearing their hair because they keep coming up to this point, waiting for someone to say go, and no one ever said go. And that's the problem I see with, if we divested away from the state agencies. Bad news at Massachusetts Board of Pharmacy. Bad news at what happened, but at least they have reacted in what I would consider a sensible way. I can't say the same for the FDA, and it's painful for me to say that.
Well, if I can go back to an old Paul Newman movie, it appears what we have is a failure to communicate between regulatory agents and enforcement agencies.
Dr. Gottlieb, let me just ask you, because you have some experience working within the agency. Is that not correct?
Look, I think NECC was breaking existing law. They were acting as a large-scale manufacturer under the guise of a pharmacy license. They were compounding identical versions of FDA-approved products. They were doing it in bulk. They weren't doing it in response to prescriptions. They had had previous GMP violations, so they were a known bad actor. I think the issue isn't necessarily what is FDA's authority. FDA has extensive authority. I think that the challenge is that they don't have ease of administering that authority because they don't have the ability to compel the submission of certain information, and it's not the posture by which they typically regulate. In the case of compounding, in many cases, FDA is forced to have to make an affirmative case before it could go in and start to do its work. Typically, the FDA doesn't regulate that way. Typically, the FDA regulates from a posture where they compel submission of information to the agency, and then they're able to target their activities based on that information. So this is, under existing law, they have extensive authority in my view, but it's authority that makes it administratively more burdensome for them in this area than others.
But, the concept of an affirmative case, for heaven's sakes, the system was blinking red for years. For years. I mean, you had whistleblowers. You had people bringing brochures in. You had people showing up saying, this is what we heard at a conference. These guys were clearly skating way beyond the edge, way beyond the fringe. And, okay, well, it may not be the normal FDA posture to take an affirmative case when the evidence is laid in front of you.
Well, this one was obvious.
It shouldn't take years to come to the conclusion of filing the action that eventually closed the NECC. Is that correct?
This was a known bad actor over a long period of time, including, frankly, the time in which I was at FDA. We sent out a warning letter to this firm in 2006.
Okay. Thank you, Mr. Chairman. I'll yield back.
Chair, thanks. Gentlemen, and now recognize the ranking member emeritus, Mr. Dingell, for 5 minutes for questions.
Mr. Chairman, I thank you. First question is for Ms. Russell of the National Association of Boards of Pharmacy, and also Ms. Cassell of the Pew Charitable Trusts. Ladies, do you believe that there is regulatory uncertainty regarding the FDA's role in overseeing compounding pharmacies, yes or no?
Yes.
Yes.
Now, these next 2 questions are for Ms. Russell. In your testimony, you mentioned that NABP partnered with the Iowa Board of Pharmacy to inspect pharmacies which deliver compounded drugs into Iowa. Is that correct?
Yes.
Now, in your testimony, you also mentioned that your inspections found that what occurred at NECC was happening elsewhere. Is that correct?
Yes.
Could you briefly describe what you found at some of the facilities where you found a repeat of this kind of situation?
We found large-scale operations similar to what NECC was doing, where they were allegedly compounding or producing bulk quantities of sterile injectable products, some that were essentially copies of commercial products. We found issues with compliance with standards for sterility compounding, and basically that they were shipping non-patient specific drugs into the state of Iowa in violation of Iowa state law.
What did the Iowa agency do about this?
Iowa is in the process of they've got 3 attorneys now working on the inspections that we provided, and they have issued notices of regulatory hearing for 5 of the first 6 pharmacies that we went in, which were some of the larger scale operations. Those hearings, I believe, will be held in June this year, next month.
They seem to be in great haste. Am I correct?
Pardon?
They seem to be in great haste to get around to processing this matter. Yes or no?
Yes.
I don't see it that way. Now, Ms. Cassell, in your would you submit also for the record other details of the events that you found, if you please? Now, in your testimony, you mentioned there's been 19 significant compounding errors since 2001. Is that correct?
Yes, 20 including NECC.
Okay. Would you, for the record, submit the details of those events, please,
Yes, sir.
to us? Now, How many people died as a result of these incidents?
Not including NECC, there were 22 deaths associated with these incidents, and including NECC, there were 77.
Could you submit for the record the details on these?
Yes, sir.
If you please. Now, as far as you know, have there been further problems with compounding pharmacies after the NECC outbreak? Yes or no?
Yes, we've seen a number of recalls related to quality problems with compounded drugs this year.
Could you submit again for the record what you found in those matters?
Certainly.
Could you give us a brief, perhaps, picture of what you found done in these instances and whether this was the responsibility of the state agencies or the feds?
Well, I can give one example. There was a recall by a Georgia compounder this year, I believe in March, of all sterile products because there were infections and at least serious eye infections in at least 5 patients associated with a contaminated eye injection. In this case, this was a nationwide recall, so if Congress is considering a new regulatory system that's clear that large-scale compounding of high-risk sterile products would be explicitly under FDA oversight, I think we would have had a much better chance of ensuring the safety of those processes.
Particularly since they're shipping all across the United States, and this is touching many agencies, many states, and people in many states and agencies. Is that right?
Yes.
Now, and by the way, thank you for your patience. It lets me get a lot more questions in. Would you, for the record, please submit the information that you have on these instances?
Yes.
Now, in your opinion, is the outbreak at NECC an exception to the rule, or do you believe that it is but one example of a larger problem?
It's certainly an extremely horrific example, but it's just one of the larger issues we face. We acutely need greater clarity on oversight structures for large-scale compounding.
And one of the things we have to do is to clarify it so that everybody knows who is supposed to and who can do what. Is that right?
Yes.
Because we have the court cases that have screwed up the interpretation by both state and federal agencies on this matter. Is that right?
Legal uncertainty is one problem, as is changes with the industry and the emergence of the large-scale sector.
I've used more than my time. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. Now recognize the gentleman from Virginia. Mr. Griffith, 5 minutes for questions.
Thank you, Mr. Chairman. I have to tell you all, and I appreciate all of you being here, that I think part of the problem is that we have a clash of two worlds, the legal world and the medical world. Because when I look at the authority granted to the FDA under the code, with the exception of the advertising overreach, which was stricken down, there's plenty of authority already there to get to every problem that you all have raised today. And that's my concern. And I asked the doctor earlier, and she was very kind, that, you know, this happened, the Supreme Court case came down that dealt with the Ninth Circuit in 2002. Where was the request to Congress to clarify? Because the only clarification is that the rest of the authority granted, with the exception of the advertising provisions, should have been reenacted by Congress. Now, can we tweak it a little bit and make it a little bit better? I'm sure we can. And I'm certain that we will work on that, because none of us want to see this problem happen again. But I heard one of the witnesses, and I don't remember which one now, say that they understood that there had been problems, you know, getting the records and getting into things. And in fact, I think because the medical world and I was a courtroom attorney, and so maybe it's a little different, not just attorneys, but courtroom attorneys, they see things differently. So I asked legal counsel, who was here at a previous hearing for the FDA, do you have any trouble getting warrants? Well, and I expressed that my opinion always was, as a defense attorney, criminal defense attorney, that the government didn't have too much trouble getting warrants. He said that wasn't my experience. I asked him to get me information. Yesterday we received that information, and sure enough, the FDA cannot point to a single example of where they requested a warrant where they were denied that warrant. So while the common belief is they have a hard time getting this information, the data would indicate otherwise. I also asked, how long does it take you to get the warrant? And they said in the most recent administrative warrant we sought for a pharmacy, 10 days passed between when the refusal was encountered and when the warrant was signed by the magistrate judge. I've got to believe that if, as somebody said earlier, the blinking light, the red light warning had been going off for years, that if instead of being timid and being afraid of the law, the medical folks had burst in as often police officers have to do. If they think somebody has a DUI, they may not win the case in the end, but they get that person off the road, at least temporarily, to see what's going on. That's what should have happened in this situation. Would you agree with that, Mr. Harmison, that that's probably what should have happened instead of coming in and trying to do a rewrite of the law?
Yes, sir. If there's public safety at risk, the State Board of Pharmacy absolutely has the power to come in and say, wait a minute, you're shut down.
Yeah. And I think that the guidelines that were worked on, never fully finalized, but that were worked on in the draft guidelines of August of last year that we didn't learn about until March of this year, make that clear as well, because it goes through and when it talks about distinguishing between, as you all have called them, different names, large-scale producers or production of compounded drugs, large-scale manufacturers. I think they're manufacturers, and I said in one of the earlier hearings, I can call myself the Duke of Earl if I want to, but that doesn't mean I'm getting diplomatic immunity. And that's where I think we run into this problem. But when they did that draft, they said when you're looking at whether or not somebody is, doing a compounded drug product that qualifies for the exemptions, they came up with 10 guidelines. And they're all significant and important, but I noted with interest 2 of those. Number 8 says the licensed pharmacist or licensed physician does not compound regularly or in inordinate amounts any drug products. Number 10 says that you should have a memorandum of understanding with the state so that you can work out these areas that aren't clarified. And in a state where they've not entered into a memorandum of understanding, the pharmacist shouldn't be sending to another state more than 5% of the total prescription orders dispensed or distributed by such pharmacy or physician. These seem to me to be reasonable restrictions, and it makes the definition that I think each one of the witnesses here today is looking for, distinguishing between the traditional pharmacy that's doing some things for their patients and their customers and these large-scale manufacturers who are, in fact, in my opinion, they're not compounders in the traditional pharmacy sense, but they are, in fact, manufacturers. I look forward to trying to make sure that we clarify some of that, because I do think that part of the problem is not having some street lawyers at the FDA who know that sometimes you got to go in and kick the courthouse door down and say, here's what we're doing. And when the judge sees the risk to the public, he'll say, okay, I'll sign the warrant. Okay, we'll shut them down, at least until we can find out whether or not they are a risk to the public. I think the authority already exists for that. I just think there's been some timidity in the legal department at the FDA. And when you talk about registration, when you look at the rules in Section 510 of the Act, I think it's pretty clear that unless you're a small-town pharmacist, you're supposed to be registering anyway. Does anybody disagree with that? Dr. Gottlieb, do you disagree with that?
No, 510 has a requirement for registration. I think 503A actually lays out some criteria to try to distinguish, these illegitimate compounders from the legitimate ones. So the language does exist, and even 503A could be better interpreted in regulation, but I think the compliance policy guide, which you just quoted, is a very good start for that.
Yeah. I think they did a nice job in that guidance. I'm not going to say I would agree with every word of it, but most of it's pretty good stuff, and it indicates the FDA had the authority to move forward even under the rules that they now say they don't have the authority to do. With that, I see my time is up, and I yield back, but I do appreciate all of y'all staying through 2 vote series on a long day. Thank you.
Chair, thanks, gentlemen. And with that, we again thank the witnesses for your patience. That concludes the questions of the members who are present. There are other questions I'm sure that other members who are not here will also like to submit to you, and we'll ask that you please respond promptly once you receive those questions. And I'll remind members that they have 10 business days to submit questions for the record, and members should submit those questions by the close of business on Thursday, June the 6th. Very informative and important hearing. Thank you very much for your attendance. Without objection, the subcommittee is adjourned.